tomorrow, so that 22nd is the.
Yeah, 2 memos.
Not memo, the notification I have given for complete. And one more, if your lordship.
No, only one. Only one.
Court number 10 ର ଏଟା ଖାଲି
Court number 10 ଆଜି function କରୁଛି?
ନାଇଁ କରୁନି notice ଅଛି ଏଟା full gratuity non payment otherwise any date.
No, sorry, unless it is exceptionally urgent, I will not take up any other courts now. Yes,
second of which question.
Item number 20 on behalf of Dilip Kumar Mahapatra. Let it come next week, my lord.
item number
20, my lord.
of supplementary list.
Yes, my lord.
All right, release this matter. When do you want?
Next week.
All right, release this matter next week.
Item 24, my lord. Mediation, my lord, partly success. I pray 20 days, my lord, interim mediation, further mediation is there, my lord. Matter is going to
Submitted that further mediation is going on, and therefore the matter may be adjourned. List this matter. 22nd August. Yes.
Matter item 17, my lord.
Item number 37, my lord, weekly list. I'm not feeling
Item number 37.
weekly list
List.
in my lord. I'm suffering from viral fever, my lord. That's why I'm upon adjournment, my lord.
This 2003 matter. No. 2003 matter. I'm not going to.
I'm not feeling well today, my lord. That's why I'm sorry.
I can adjourn it to tomorrow. Man, it will remain in the list. It will be submitted tomorrow again.
That's why I'm submitting, my lord. Wait.
Release this matter next week. It is made clear that no further adjournment shall be granted. Yes.
No, item 17, my lord.
17 of which list?
Count of the supplementary.
Yes.
The counter has not been filed.
Yes.
So,
A week's time be. All right. Release this matter. What a week for us. 8th August. On 8th August. Not affidavit. It may be filed in the meantime. Yes.
well, item 37, my lord. Though their lordship is directed for a speedy post, but I have unfortunately I have filed that.
Let it come. Let it reach. Let it reach that order. Yes. Do we mention the amendment? Yes. Item number 1. Sir, please kindly leave that chair. Sir. That is the arguing counsel's chair. এটা কোন থিলা মানে section আসছিল IA 9118 of 2024 application for amendment of the cost title of the writ application. The proposed amendment being formal in nature, same is allowed. Consolidated cost title be filed.
Just now.
Consolidated cost title has been filed in the court.
Mine.
You are filing it now?
Mine.
Yes. Judgment pay reserve. Yes. Heard further argument?
The lordship service. I have prepared the written notice.
Yes, you can.
Just.
We hearing more corona. I'm closing it. Heard further arguments? Posted for judgment.
Consolidated copy already.
Judgment reserved. No, judgment reserved. Yes. Yes, please.
Item number 2, fair second, sir.
Petitioner is asking personal transfer petition from Judge Family Court Noagar to Judge Family Court Kotak minor.
Yes.
128 proceeding filed by the opposite party. Why?
Yes, 125.
120.
Yes.
Petitioner is army personnel
Yes.
staying at Jabalpur,
Yes.
filing transfer petition from Judge.
So how does it matter if it is transferred to Cuttack or Noagar? How does it matter? You can appear virtually.
I am appearing on that day. My father-in-law and my son-in-law attacked me, and I have given FIR, my lord. Currently, it's an of 3, my lord.
Maybe.
My life is danger, my lord. Currently, it's an of 3.
Learned State Council shall take instructions with regard to the FIR lodged by the petitioner. List this matter. What a week for, huh? 1st August.
Extra copy maybe, sir.
An extra copy of the transfer application be served upon Learned State Council, who shall obtain instructions with regard to the FIR lodged by the petitioner. List this matter on 1st August.
Stay for the push.
In the meantime, if any
29
application,
29 is.
if any application for adjournment is moved on behalf of the petitioner in the court below, the same shall be considered, having due regard to the date fixed for hearing of this case. Yes.
Item number 3.
Item 3, yes.
The petition the wife mailer filed
Yes.
this petition the transfer of CP case number 470/2024 from the court of the Law and Judge Family Court of Bhubaneswar, Law and Court Judge Family Court of Jagatsinghpur.
All right, notice. Notice adjournment.
Mailer.
Item number 4.
Yes, item 4. What was the?
ଗୋଟେ ଆଇଏ ଦେଇଛି ଆମେଣ୍ଡମେଣ୍ଟ ପାଇଁ ସେଟା ଟିକେ ଅନୁରୋଧ କରୁଛି ଆଲାଉ କରିଦେବେ।
Well, previously, this petition under approved before this honorable court, there was a direction to consider his repentation. For non-compliance of the order, my lord, he had filed one contempt petition. And in the meantime, on the basis of this Mamta Naik case, he filed another case. So there was a direction to me to obtain the instruction with respect to compliance. of
What
the
happened to that representation?
And my lord, we have submitted a copy since month of February 2024, that has been disposed. So he was granted with the liberty to file the amendment petition to incorporate the same. So it is formal in nature. This will be allowed.
Then. এটা কাই? এটা আছে লিস্টে 91994.
What is?
This is an application for amendment of the writ application to incorporate certain certain developments that have occurred during pendency of the writ applications. On going through the schedule appended to the IA, this court also finds that the proposed amendment is formal in nature. The Learned State Council also fairly submits, or Learned State Council also does not have any serious objection to the amendment being allowed. In such view of the matter, the IA is allowed. Consolidated cost title incorporating the amendment be filed within a week. List this matter.
It is not only with confining with the constitutional matter.
Consolidated writ application.
Sorry, he also sought the copy of.
He has filed it. You have filed it. Consolidated writ application incorporating the amendment is filed in the court. Same be kept on record. Yes, you are ready?
No, my lord, this is against the rejection order, my lord. Now it is under challenge. So
Learned State Council requests for some time to obtain instructions with regard to the amended pleadings. List this matter. Long, he is appearing in person, so naturally. 1st August. 1st August.
first of
ହେଲା ସେ ଆଣତ ତା ପୂର୍ବରୁ ଜଲ୍ଦି କଲେ କଣ ହବ ନା ସେ ଫୁଣି ଟାଇମ ନେଗିବ
ମୋର ଗୋଟେ ସମିଶନ ଅଛି ମୁଁ ଟିକେ ଅନୁଦେଲ କହିବି।
କୁହନ୍ତୁ।
ଗୋଟେ ପି ସ୍ମିତାରାଣୀ ରାଓ ତାଙ୍କର ଅର୍ଡରଟା ହେଇଛି ଏଇଟା ଏଇ ବେସିସ ରେ ହେଇଛି ମୁଁ ତ ପ୍ରଫେସନାଲ ନୁହଁ ଟିକେ ଏଲାବୋରେଟ କରିପାରିବି। ମାନେ ମମତା ନାୟକର ଅର୍ଡର ପୂର୍ବରୁ ତାଙ୍କର ରିଜେକ୍ସନ ଦେଇଥିଲେ ତ ସେଇଥିପାଇଁ ତାଙ୍କ ଅର୍ଡରଟା ସେ ଗୋଟେ ଦିନ ହିୟରିଂ ରେ କମ୍ପ୍ଲିଟ ହେଲା। ଆଉ ଗୋଟେ କଥା ଏଇ ଯୋଉ ରିଜେକ୍ସନ ଦେଇଛନ୍ତି ମାଇଲର ସେଇଟା ମତେ ଓଭର ଏଜ କରିକି କାଟିଛନ୍ତି ଯେତେବେଳେ ଆଟ୍ ଦ୍ୟାଟ ଟାଇମ ଆଡଭର୍ଟାଇଜମେଣ୍ଟ ସମୟରେ ମୁଁ ଇଲିଜିବଲ ଥିଲି ଏବଂ ଇଲିଜିବଲ ଲିଷ୍ଟରେ ମୋ ନାଁ ଅଛି। ସେଟା ଟିକେ ମେନସନ
ଦେଖିବା
What say to please?
ସେଇଟା କପି ଗୋଟେ ଦିଅନ୍ତୁ କପି ଦିଅନ୍ତୁ ସେ ଜିନିଷ ଦ୍ୟାଟ ଡୋଣ୍ଟ ୱରି ୱିଲ୍ ସି
ଆଉ ଟିକେ ଏର୍ଲି ଦେଇଥିଲେ ଟିକେ ଭଲ
ଆର୍ଲି ଡେଟ୍ କଲେ ସେ ଆଣିପାରିବନି ଲାଭ କିଛି ହବନି।
My lord, in this case, my lord, because I was very much available on that day even. There, my lord, your lordship had disposed of this case with a direction to submit a repentation. Here, my lord, the case is that, my lord, a repentation
It has been rejected.
It has been rejected.
Now we'll just see whether
Whether the
the
rejection-
order of rejection is proper or not. That is the only thing to be seen now.
And my lord, the order of rejection is prior to your lordship's order. So that is why
Order in
in Mamta Naik case.
Mamata Naik.
So
What was
therefore-
decided in Mamata Naik? That
the month
their
of-
preferential.
Yes, ma'am. Yes. So, my lord,
Is that relevant here?
I found, my lord, some kind of relevance is there, my lord. So that is why, my lord, I just want to take the time to get the instruction whether there can be a different decision in that rejection order.
All.
If Mamta Naik case will be made.
No, he says that he has been treated as an overage candidate.
Yes. So
But when he had applied, he was in time. He was within the age.
these are factual.
Now he has become overage.
Yes. So these are factual assessment. I will clarify the same.
Okay. All right.
in the
All right.
instruction.
ସେ ଆସୁ 1 ତାରିଖ ହିଁ ଆସୁ କାରଣ ତା ଭିତରେ ସେ ବିଲକୁଲ ଆଣିପାରିବେନି ଲାଭ କିଛି ହବନି ବଟ୍ ଅନ୍ ଦ୍ୟାଟ୍ ଡେ ପ୍ଲିଜ
Sure. I'll do that.
ଲେଟ୍ସ ଦିସ୍ ମ୍ୟାଟର ଅନ୍ 1st August. Yes.
Item number 5.
Obliged.
Yes, item 5.
Item 5, please, ma'am. My lord, petitioner's prayer is for appointment as CCAS like, my lord. It is also covered by Lordship's judgment.
Mamta Naik.
Mamata Naik, my lord.
ମୁଁ ଜାଣିଛି କେମିତି କଭର୍ଡ ହେଇଛି ବୋଲି ମୁଁ ଜାଣିଲି
My lord, Annexure 7. my lord.
କୁହନ୍ତୁ କଭର୍ଡ ଫଭର୍ଡ ହବନି ଆଜ୍ଞା
My lord,
ଏଇ
here-
କୋର୍ଟରେ କଭର ହବନି ମୋ ଜଜମେଣ୍ଟ ହଉ ଯାହାର ଜଜମେଣ୍ଟ ହଉ କଣ ହେଇଛି ଫ୍ୟାକ୍ଟ କୁହନ୍ତୁ ମୁଁ ଶୁଣିବି ଯଦି ମତେ ଲାଗିବ ଆଜ୍ଞା କଭର କରିବି
my lord, the opposite.
unless the state council also admits that it is covered.
My lord, this is not covered by Mamta Naik's case, but this is covered by P. Smita Rani Patra case. Wherein after going through the entire issue, the lordship granted the liberty to the petitioner to file a fresh representation to consider that case.
So we can pass the same order if you want.
Yes, my lord. My lord, in P. Smitharani Rao case
Yes.
also same.
Give me pass on that piece, Mitarani.
ସେ ଏବେ ଯୋଉ ଜିତେନ୍ଦ୍ର ସାହୁ ଯୋଉଟା ଇନ ପର୍ସନ ଦେଲେ ଯୋଉ କେସଟା
ସେଇଟା ମୁଁ ଆପଣଙ୍କୁ ଫେରେଇ ଦଉଛି
ସେଇ
Oh, so consider the case in light of Mamata Naik.
yes
So that will suffice. That will suffice.
yes
You এই অর্ডারটা পাস করে এতে ঠিক আছে চেঞ্জ হবো এটা আপনি প্লিজ গিভ আ কপি
Yes,
না ওটা
I-
গোটা কপি করে দাও না মানে এই বার করে দাও
I think
এটা বার করে দাও
uploaded my lord.
No, we'll find it out from REA. We'll find it out. What is the date of representation? What is the date of representation? What is the date of appointment and all those things?
My lord, we have approached, my lord, but they have not considered. My lord, I have also enclosed, I have also mentioned.
I am granting you fresh liberty.
Yes ma'am.
Yes, my
And
lord.
fresh liberty.
ନାଇଁ ସେଇଥିରେ ବି ସାର୍ ଦିଆହେଇଛି fresh representation.
Fresh representation ଆପଣ ସାଇଡ୍ କରିବେ
That case, it was rejected prior to your lordship judgment, my lord. Her case.
Now I am giving you another opportunity.
My lord.
Then let them consider in light of Mamata Naik.
My lord.
All disposed of.
Item number 6.
Not within narrow compass. Not I uploaded my all certificate, reject certificate online, but I failed to submit on the date. It was for physical verification. My humble submission, Milord, there is some unavoidable situation I could not produce. I made an application to permit me 2 days time. Therefore, Milord, the rigidity is Milord, only it is not a question of Milord relating to as to whether I possess an eligibility qualification on the date fixed, Milord. Only it is for the proof of the document which is already uploaded. Therefore, I made an application under Annexure 3, Milord, at page 11 that may be considered sympathetically.
There is no sympathy in law, Mr. Das.
No, Milord, apart from that, pardon. If you are-
No sympathy, no love, no hatred. Nothing is there in law.
On the
Law is bereft of emotion.
yes, that I understand. But
Yes.
But I do not have any objection with respect to representation disposal.
No. No.
But
It is very rigid. You have to produce the original
yes,
originals of the testimonials during selection.
my humble submission. But
And my lord, that is-
in the Dolichan
that
case,
is also available in the advertisement condition.
like, Milord, in Dolichan case, Milord, that I was house stepping for lordship in Dolichan case, that the rigidity in relating to proof of document, which I've already uploaded, and it is within them.
I'll tell you, Mr. Das, what will happen is, now, unless you file the documents, which is a mandatory requirement, original documents, you will be treated as ineligible. What will happen is, by granting you time, some other eligible candidate will be affected.
Milord, I have already, my all certificate I've given, uploaded.
So
Only
let him dispose of this representation, let him dispose of.
in case of the Milord.
The limited grievance of the petitioner is that she was an applicant pursuant to the advertisement issued on 26/2024 for engagement of Anganwadi worker in Podia Bhanga Anganwadi Center under CORAM Panchayat, under Guru Janguli Gram Panchayat in the district of
Sorry,
in the district of Hon'Ble. She claims to have submitted photocopies of all the relevant testimonials along with her application online. She submitted a representation to the sub-collector on 6/7/2024, requesting for some time to produce the originals of the documents, originals of the photocopies of the documents already uploaded by her. So her grievance is that the said representation has not been considered as yet. In view of such innocuous prayer, the writ application is disposed of, directing the sub-collector Talcher to consider and dispose of the representation dated 6/7/2024, comma, if not already disposed of in the meantime, as early as possible, in accordance with law. Stop. In disposing of the representation, the sub-collector shall take note of the fact that the petitioner has already uploaded the photocopies of the documents, of the concerned documents. Yes, at the time of submitting her application.
Oh, public.
Yes.
Item number 7.
Mr. Kara, even though I had closed it, but after you left, Mr. Patnaik claims that he was not heard. Though I don't agree with it.
Objection.
No, I don't agree to that. But since it amounts to, making an aspersion on the court, I granted another opportunity. Yes,
Actually,
yes,
Justice
Mr. Patnaik, you are free to argue. Please argue. Please argue, sir.
I don't know how to put my expression.
Sir, mic ta pakade kuhtu, better habo. Yadu gunchi asundu, mic ta pakade kuhtu.
Learned friend, senior my lord, finish. It's necessary to add a small picture.
The fact of the case in short, on behalf of the OP number 4, 5, 6 is that OP number 4 and 5 are governing body and principal. OP number 4 and 5 are governing body and principal. 6 is the person against whom the petition has come and said that OP number 6 is not the proper person to be appointed or reinstated or anything of sort, but he is the proper person. So my argument before my lord is, before I start it, I have prepared a little dead chart so that it will convenient for my lords to go through it.
Yes.
Well, it's 28/3/95. Rangadhar Paike, the petitioner filed appeal before the Director of Higher Education as not permitted to sign the attendance register. 24/11/95, DPI allowed appeal. 13/2/1996, OJC number 1289/96 filed by the petitioner Rangadhar Paike to implement the DPI order dated 24/11/95. 19/2/96, OJC number 1481/96 filed by Ramakrishna Mahato, OP number 6, challenging the DPI order dated 24/11/95 as illegal and not to implement the DPI order. 6/5/96, OJC number 4085/1996 filed by governing body, OP number 5, considering the order dated 24/11/95 of the DPI as illegal. 1/7/2007, the above three cases were disposed of by quashing the DPI order dated 24/11/95 and remanding the matter to DPI for fresh hearing. Honorable Justice Tripathi and Honorable Justice R.N. Mishra. 11/6/2008, on remand, the DPI had and held that Ramakrishna Mahakur, OP number 6, is the genuine PT of the college. (11/7/2008), Rangadhar Paike, the petitioner being aggrieved by the order dated 11/6/2008 of the Director of Higher Education, filed a repetition WPC number 9868 of 2008, challenging the said order. 19/9/2008 WPC number this disposed of with the direction to DPI to release and dispose of the appeal as the appeal heard by the DPI is not the same DPI who has passed the order. Honorable Justice BP Das and Honorable Justice R.N. Bishwa. 25/6/2009 DPI disposed of appeal holding that Ramakrishna Mahakudu OP number 6 is the senior PT, so he holds the first post. 4/12/2009 being agreed by the order of a DPI dated 25/6/2009, the petitioner filed the present writ petition number 18641 of 2009 challenging the said order dated 25/6/2009. 21/2/2011 OP number 6 Ramakrishna Mahakudu appeared in this writ petition. My lords, I pray to my lords to kindly see the position and the fact of the case of OP number 6. He has filed the counter, and only I want to show only necessary part of the things. My lords, will kindly see page 80 of my counter filed by OP number 6.
Yes.
There, he has given the detailed description of his appointment, continuance, getting the aid, block grant, thereafter granting aid with effect to 1694. Only I will show the annexures. This is the fact. My lords, may kindly page 87. Page 87.
Yes.
Ramakrishna Mahakudu, OP number 6, son of this and this, is hereby appointed as a PT in usual scale of pay. This is appointment letter.
Yes.
This is the letter number is 25, my lord, top, at the top. Importance is, he has given the appointment letter where no number is there. But here he has been appointed by letter number 25, letter 30/10/86. Thereafter, my lords, kindly see. He has given his next page joining report. That is 15/11/86. Did I get it?
Yes.
Thereafter, by next, my lords, the resolution dated 20/12/86. There, my lords, at page 91, that is the resolution of the governing body after the appointment, my lords. Sashta Prastav.
Yes.
Sri Ramchandra Mahakudu PT नियुक्ति संबंधे पूर्व प्रस्ताव अनुजाई महाविद्यालय जड़े पीटी श्री रामचंद्र महाकुड़ नियुक्त होइथिबार ओ उक्त व्यक्ति कार्य जोग देथिबार सूचना संपादक देले ओ उक्त नियुक्ति को अनुमोदन करने को प्रस्ताव आगत कले विधिवत आलोचित होई गृहीत हैला ओ से अणतालीम प्राप्त होइथिबारु आगामी 4 वर्ष मध्य तालीम प्राप्त होई प्रमाण पत्र उपस्थापित करने निर्देश देवाक बैठक सर्वसम्मति भाव संपादक को क्षमता प्रदान करागला। आगामी 4 वर्ष मध्य जदि से निजर तालीम प्रमाण पत्र देवाक अक्षम होती तेबे तांको कामरू बहिष्कार करने संपादक को क्षमता प्रदान करागला। I have submitted before my lord the original resolution book, everything from the date of appointment till date. Thereafter, my lords, may kindly see 2989 at Nabam Prastav at page 93. Page 93.
Yes.
Ramakrishna Mahakudu को PT study leave मंजूरी संबंधे श्री रामकृष्ण महाकुड़ पीटी भावे महाविद्यालय जोग देइथिले हैं ट्रेनिंग रे हासिल करि नथिबारु ओ सीपीएड कोर्स ग्रहण करि नथिबारु से छुट्टी रे जाई उक्त कोर्स संपूर्ण करिथिबा विषय संपादक बैठक रे उपस्थापन कले। यह आलोचना होई सर्वसम्मति क्रमे निष्पत्ति ग्रहण करागला ओ तांकु एथिपई 1 अगस्त 1989 10 मास छुट्टी देबा संपादक को अर्पण करागला। उक्त ट्रेनिंग पीरियड रे तांकु वेतन कॉलेज रु देबा सिद्धांत ग्रहण करागला। Thereafter, after he came back and he joined. My lord, this is the eligible list where my lords may kindly see serial number 3970.
Yes.
Ramakrishna Mahakudu, physical teacher, first from this to 1965 to 1986 appointment. There, next page, After examining the, did my lord get it? Next
Yes,
page, my
yes.
lord, 95. After examining the relevant documents, the above employees have been found eligible for consideration of a block grant under grant of GI order 2009. Objection, if any, to the above list with the validity, ground or supporting documents is invited within a period of 7 days from the date of publication. Then after submission, that list I read out and my name is there. Thereafter, my lords, I complete next page. I completed my course, my lords. Next page. The Board of Secondary Education certificate from this. Thereafter, my lords, when there were some difficulties in getting the GIA, I approached my lords, and my lords directed that his case should be considered. The state government is directed to examine. Honorable High Court passed the order. The state government is directed to examine the eligibility of the petitioner for getting the benefit under the GIA order 1994 and release the granting aid in his favor in accordance with the aforesaid rule. The differential salary as well as the arrear, if any, shall also be paid to him. The entire exercise shall be completed within a period of 4 months from the date of communication of this order. Thereafter, my lords, next, it was considered and he was allowed Ramakrishna Mahakur, PT first post from 1694 1/3. Thereafter, they have been given 1694 1/3, 1696 2/3, 1698 rest for full. He was given. Thereafter, he has been continuing as such. In the meanwhile, my lords, on 5/6/15 also, it was repeated the same thing, and another letter was submitted by the government. My lords, next, my lords, prior to this GI order, the 2014, thereafter he has been given block grant. Because it was given, because I came to Honorable High Court, Honorable Director, thereafter given. My lords, F/6, that is page 104. Pursuant to government in the Department of Higher Education, Orissa, letter number this dated this, payment of a block grant with effect from 1/2/2009 is hereby accorded in favor of 13 number of teaching and 18 number of non-teaching staff of the Kaptipada Junior College, Nuasahi, District Mayurbhanj, as per the details given below. In terms of Orissa aided colleges, aided junior colleges, and aided higher secondary schools, GI order 2009. My lords, my name is in serial number 21. Next page 105. Ramakrishna Mahakur, first, the 15/11/6, this amount I have been given. So, my lord, the entire purpose of a submission of this records before my lords is that Ramakrishna Mahakur has been appointed by following a due procedure of law, and resolution has been passed one after another to give him appointment, to go for training, and when he came back, then join in the training. All the resolution, I have given the original books. In addition to this, I have also submitted from the date of my appointment till date, my lords, I have been given this salary, and my original records are with my lords that I have submitted. Nowhere there is any complaint from anybody else. But
Yes, please.
Rangadhar Paikrai, the petitioner, has put somewhere signature. Is, for example, pay scale, payment of the salary. There he has, his name has been written, Ramakrishna Mahakur. He has put his signature over the revenue stamp. And his name has been written below his name somewhere, not everywhere. And revenue stamp is there, but he has not been permitted to put his signature. So the irregularity and illegality has been committed for him as and when necessary, because the records are with them. But what records I have annexed with this, only I pray, my lords, that may kindly be taken into consideration, which they have not denied that these are the records which I have annexed it or added it falsely or out of imagination. That is not there. Thereafter, my lords, governing body has also passed, filed a counter. page 68, my lords. He has made an application before the appointment to the secretary of the Pada College, application for the post of a PT. I have come to know from a reliable source that the post of a PT is lying vacant in your college. I offer my candidature for this post. Therefore, next, my lords, I have selection was held and he stood first, and petitioner in this case stood second. So he was given appointment. That is appointment letter, page 69. Sir, and he
First and second means there was a selection process.
the selection process.
Where is that document to show that there was a selection? Whether there was an open advertisement or what?
There is an advertisement.
Because
My lords,
you just now read out the Annexure A/4 series, it is the first document that he had submitted an application. On his application,
my lords, the opinion number 6 had submitted his application.
that's true, that's true.
Yes.
So it does not show that it was pursuant to any advertisement. He simply says that I came to know from a reliable source that the post of PET is lying vacant.
My lords, the college was established in 1986. Thereafter, they just give a notice in the notice board and
No, is that the case? I want to know that. I want to know what is the specific stand of the government.
I must file an affidavit to the next.
What is the specific stand that since you said that he was appointed by following a due selection process?
Yes.
Due selection process obviously means that the notice must be available for everybody.
Selection order is there. I shall give you the rest copy of all these things. With
That's all right. That's
with
all.
affidavit.
I'm not denying. I just want to know. In the interview held on कितने और candidate ଥିଲେ कौन ଥିଲା? It happened recently. I've seen it earlier also. I had seen it.
Yes.
What I would like to know.
Yes, I shall give it. I will carry
Because you just now referred to this application submitted by opinion number 6. He says, I came to know from a reliable source that the post of PET is lying vacant.
Yes.
So whether it was advertised, it may have been pasted in the notice board. Fair enough, doesn't matter. But was it that? Because this application does not say so. It says that he had applied on his own.
I shall file an affidavit.
All right.
I'll tell you what has happened.
Heard in part, in course of hearing, attention of this court is drawn to an application submitted by the opposite party number 6 on 20/10/1985, the 85 no 86, addressed to the secretary of the college. This court would like to know whether the post of PT was advertised in any manner. Sri Patnaik and Council appearing for the management of the governing body
Yes, yes.
shall take instructions in this regard and file an affidavit
Yes.
stating all the relevant facts. Then thereafter we will proceed because it is your case that he was validly.
Yes,
appointed.
yes. There are some errors in procedure.
Yeah. List this matter on. When do you want? Next week or 29th rasu? 29th nue 30 amar kebe hochi?
30.
1st August hobani. No, 1st August. 1st August. Yes, Mr. Karo.
Okay.
I know what is going through your mind. But you see, this is his specific stand. But the document that he has shown is not in consonance with his statement.
Very correct. Because my application for appointment says that I came to know also in 87 that a post is lying vacant. So far as the petitioner is concerned.
So,
Office number 6 in 86 says that he came to know.
No, Mr. Karo, I'll tell you one thing. If any of you say that, both of you, it is meant for both of you. If you say that it was after following a due selection process, so this court would like to know whether the post was advertised or not.
Yes.
Na khali mota application dele mo china parcha lokoli mota darkhast de mo kar debi chimta
The
hola na.
learned friend would be able to, because is in a
He is also for the management. Yes.
since he is appearing for the
On 1st of August, thereafter it will not be adjourned. Don't worry.
obligation.
More than the delay, we will have to find out the truth.
Yes, yes.
I think my learned friend for the state has already.
He has filed you filed all the file of the director.
Yes,
File relating to the proceeding before the director. But that will not help. That will not answer the question that I have posed.
Right. The only thing, Lord, I had submitted the counter file by the state. I have given a copy to my learned friend also. If my learned friend will be kind enough to produce the records of OJC
1289 of 1996.
We can call for that, OJC.
So it is not detail. So,
No, we can call for that record.
because in that particular case, a counter was filed by the state.
All right,
Some observations in the counter would help me.
we can call for that.
Yes.
Release this matter on 1st August along with OJC number
Which is number 1289
1289
of 1996.
of 1996. Yes.
A pleasure.
Item number 8.
1289. 1996.
Yes, Mr. Kumar, kindly.
But I'm sorry.
Yes.
Madam, I filed an application for amendment, formal amendment, because during pendency of the writ petition, the petitioner retired. So a question was raised that whether I can get promotion, the relief sought for in that writ petition. So I only think that I take a national promotion from that date. That which is the amendment.
Where is that IA? 7927.
Madam.
Yes, Mr. Hon'Ble.
I filed my objection and solved the complaint.
I'll allow it.
And because it will change the entire nature and character, the prayers are totally different. In the prayer in the writ petition, that I be given permission. Here now, without deleting that, now says that national promotion will be given. Contradictory totally.
How can it?
Either one has to be deleted or because both cannot run simultaneously. One prayer has not been deleted. The other prayer has come up. So both are contrary to each other.
I'll permit him to delete it right now.
It is better for him to file a press writ petition so that whatever facts are there, he can instead of because now it is a matter of 2015.
Keeping it pending for 10 years. For 10 years, it is, some responsibility should also be cast upon the court.
Of course.
The court has kept it pending for 10 years. And now I will relegate him to another forum or to file a press writ.
Because now he going for the amendment, that is the end, totally contrary to
This will be an anti-litigant order which I will not pass. I will allow it. I will ask him to delete that portion right now in court. Technically.
Prayer is not for that at least.
What in course of hearing it's a prayer or prayer, I will grant him to do
that. Can do that.
ये technical disorder रखिएगा मैं.
Because all the prayers if Malad will go through.
Mr. Rai, please go through. What he's saying is, I'll call it tomorrow. If necessary, you can delete it because let there not be any contradictory prayers. अब ये पूरा promotion claim करेगी.
Prayer number D, Lordship can have a glance. I have changed it. I have replaced it.
If you have replaced it, well and good. If you have
replaced it, prayer number 3 was for promotion. I have replaced it with
A, B is.
But the prayer is at page 13. Original writ petition. Madam will go through prayer A, B, C, D. All these prayers, he may substitute the amended prayer, but A, B, C, D are no longer continuing. It has become
D has been substituted.
That was
D is substituted.
D has been substituted.
Because now the prayer number A, my lord, can have a glance.
I have praying for national promotion.
Prayer number A is a disposal of his representation, and that was the order was passed in 6/8/14. The order was passed in 6/8/14 pursuant to his representation. Virtually, there is become nothing remaining to be decided in the writ petition. Virtually has become impossible.
No, but we pray, Mr. Pandra, if during the pendency of the writ application, certain developments have taken place. The court can always mold the relief and pass orders accordingly. It's not as if the court will be bound by the
original writ petition be argued so that my lord may take any decision.
Yes,
comes.
Let this happen.
Because what happens here, in 2 lines, I may be permitted to say. There was a cut-off mark of SC, ST, and general. He originally belongs to SC category. If he originally belongs to SC category, he is not qualified to be appointed in the OUT, in the post that he has got it. Because he was treating him as a ST candidate, he got the promotion. And he joined. Thereafter, he took one promotion as a ST candidate. So thereafter, when SC senior post of a SC category falls vacant, then he made a representation. No, I am a SC. Don't put me in ST category and give me the promotion of SC category. So he was given promotion of SC category. Again, that means 2 promotions in SC category. 1 promotion in ST category, 2 promotions subsequently in SC category. Thereafter, he again comes when ST category post, higher post become vacant. For that is the post of assistant registrar or the officer for the accounts officer. Then we made a recommendation. No, you put me as the ST category because originally I joined as ST category. So this is how ultimately the matter was inquired into. Referred to the collector whether he is actually SC or ST. The SC collector informed that he is actually SC, not ST. Then it was informed to the government that this is the position what's to be taken. By that time, the Supreme Court has taken a decision that the persons who are carrying the post that they are not actually to be entitled to in the category of ST category, there the commission should inquire into the matter. The matter was referred to the government, a high-level committee formed by the government to whether such a person can continue as a ST or SC. Then now ultimately that result was awarded. In the meantime, long times passed. Subsequently, it was heard that because he has already been observed and has passed long time, he cannot be thrown out from the job. Let him continue. Now thereafter he said that give me the exchange principle. The ST category promotion as a assistant registrar by way of exchange principle. Government has refused. No, exchange category is not applicable in view of the Supreme Court decision. Now that is his case. Now after in the meantime he has retired and has taken all the research dues, all the pensionary dues. He has already accepted without any objection. Now still continuing the petition, give me the promotion with backlog. Promotion is a matter where the DPC has to sit and the DPC has to consider and the OSC, the OUT rules, statutes, all these things to taken together and so that the promotion is not that easy that to after retirement of 4 years. That is how the case is now lingering. Now he is claiming that you give me the national promotion. Unless you are promoted, how question of national promotion comes to give you the better benefit?
All right.
That is the case, my lord.
Yes.
The last statement, my lord, I made submission. That at no point of time I had claimed that I belong to ST category. I had produced certificate that I belong to SC category. They considered it, they give me my appointment. And that time also, it was permissible under Rule 6, my lord. If suitable candidates are not available, they can exchange it. So whether they have done it or not, they can only OUT can say from the recruitment file under what circumstances I was appointed. So I was appointed, I was given regular promotion. So when eligibility, I came into the zone of consideration 2011 to get the promotion 2011. They said, no, you are belong to SC category, so you will not be appointed again to general category, open category. So that was kept vacant. My juniors were allowed to get promoted in 2013 and applying catch-up principle, they were placed above me and they were given appointment. So they held that I belong to SC category. So when SC category vacancy came in the earlier representation, they rejected my representation on the ground that no vacancy in SC category is there. Somebody is there, he will retire in 2015 and you will get. This is the representation while they have this. Now my claim is remitted. In 2015, that person retired and university itself held that when vacancy will be created, will be appointed. Now they are saying that you cannot be treated as SC category. So whenever, if I was belonging to the general category as per your version, in 2011 I was eligible. That you did not allow me to be appointed. So my lord, by hook or crook, they are trying to deprive me from getting my promotion. What prompted them to, after 20-30 years, I was appointed 2016 and they moved to the...
I will do one thing. I will close the matter, but before that I will allow the amendment for what approval. If it contradicts according to you, if it contradicts his main prayer, it will be at his risk, isn't it? It will be at his risk. Your objection is that it contradicts the other prayers. So that will be examined by the court. If the court finds that it is actually contradicting, then he will not be entitled to it. Aye कहते 7927 of 2024. This is application for amendment of the writ application to incorporate certain development facts, certain developments that have occurred नहीं लिखନ୍ତୁ to incorporate to substitute the prayer portion of the writ application as indicated under paragraph 3 of the IA. It is submitted that during pendency of the writ application, the petitioner having retired on attaining the age of superannuation, his original prayer for promotion no longer survives, and therefore he seeks to confine his prayer to notional promotion. Learned Counsel appearing for the university has opposed the prayer for amendment by submitting objection affidavit. Stop. He submits that the proposed amendment shall change the nature and character of the case, and moreover, it contradicts the other prayers made originally made. Stop. With regard to the submissions as above, and on going through the proposed amendment, this court feels that the petitioner having retired, the original prayer may not be available to be considered. In any case, he may have an arguable case insofar as notional promotion is concerned. Under such circumstances,
indicate that I have objected.
that I have said, I have already said. Under such circumstances, I am inclined to allow the IA. So, consolidated writ application is filed by vote after serving copy on Sri Ponda, Learned Counsel for the opposite parties. Shall we close it today or shall we close it next week?
Next week, because I will also inform them.
All right. Next week or Anshitale?
Next week also.
List this matter next week for final disposal.
Next week, may not be better fixed date.
Date say move. 1 तारीख हो. It will come on 1st July, 1st August.
1st of August. First week of August.
Sorry, 25th July. 25th July. Yes.
Item number 9.
Yes, item 9.
It's a case matter. Admittedly, the petitioner pursuant to annex number 1.
You have filed some affidavit and you were to respond.
They have already filed their response and admitting that there is a house. There is a house inside that particular center, madam.
You filed an affidavit.
I filed affidavit and response to it, madam. They have already filed their counter. Can I have a glass with
Counter na additional?
response, additional counter. 28/6/2024.
They have
Para 5.
Oh, yes, yes,
Madam,
yes.
Para 5 is relevant.
that they are not. Yes, place it.
Madam, that the Anganwadi supervisor conducted a field inquiry with respect to the residential status of the petitioner and has submitted an inquiry report on 3/6/2024.
It is there on record. It is there on record.
Hard copy.
Hard copy. Yes.
Again, presence of report on 3/6/2024 after conducting inquiry in presence of the villagers and the petitioner Srimati Pramila Kumbar, stating therein that the petitioner is not residing within the Tikarpada Gandhipada Mini Anganwadi Center area. Though within the area of Mini Anganwadi Center, there is a house, there is a asbestos house, but nobody is residing there. Rather, the petitioner is Pramila Kumbar is residing with her husband at Tikarpada 1 Anganwadi Center in their own house. Copy of the such and such. My humble submission, I do consider in my affidavit as clearly stated that after the marriage which was held in the year 2009, I continued there for in this particular center that wherein the parent Anganwadi center is situated. The Anganwadi advertisement for holding the post to take the for appointment of the Anganwadi worker of a particular center is there. There I was residing, but thereafter because of the fact that a new house was constructed by my husband, I have shifted there.
So there is no doubt, all this particular center and the Gandhipada, wherein at present I am saying, is definitely inside the same revenue village. But I was having also, my husband has also having a house in that particular area. And because of the fact that when it was, and admittedly pursuant to advertisement where it speaks at page 10, that the villagers of Gandhipada, as I have pointed out earlier also, villagers of Gandhipada are entitled to submit their application, and accordingly I have submitted. And straightaway, without making any further notice or at least to intimating these things is required, they have cancelled. So had there been any so cause or any intimation to do that, I would have given this affidavit at the relevant time. So admittedly, there is no doubt about it that I was my husband, or yes, I do concede I was at the relevant time before the 2026. At the relevant time, I was residing, and at the present stage, because of a better house manager, I have shifted to that particular place. So I was having a house.
So what has happened to the advertisement?
Advertisement, they have cancelled. They cancel it.
Thereafter, there is no further advertisement.
No, there is a advertisement and that which has been stated by the Honorable Court, and my lord is because of.
So nobody is functioning as Anganwadi worker.
Nobody is
No,
functioning.
because my lord, the petitioner had also applied in terms of the new advertisement.
Yes.
That's not concerned. It has been stated by the Honorable Court on the ground that my case, I have some case, madam.
Yeah, that's true.
And in the meantime, because of this affidavit and their own admission that I am having a house in that particular service area. So, I think my case where my can consider because to with the direction for continuance of the present petition or to give him appointment, to give an appointment.
So he has challenged the subsequent advertisement.
Yes, he had challenged the subsequent advertisement, but even though, my lord, I have produced that notification or that resolution cancelling that particular previous advertisement, my lord. For
No, just a moment. Let us find out. The original notification was for Anganwadi. Which Anganwadi?
Yes, my lord. My lord will see page
8.
Page.
अनुमोदन को निम्नलिखित ग्रामों मिनी अंगनवाड़ी केंद्र. Is it mini अंगनवाड़ी?
yes, sir.
No, mini अंगनवाड़ी
Page 16, my lord.
Page 16.
My lord, ଗ୍ରାମ ପଞ୍ଚାୟତ ନାମ ସୁବଳୟା ନୂତନ ଭାବେ ହେବାକୁ ଥିବା ମିନି ଅଙ୍ଗନୱାଡି କେନ୍ଦ୍ର ନାମ ଟିଗ୍ରାପଡା 3 and the particular ସମ୍ପୃକ୍ତ କେନ୍ଦ୍ର ଅଞ୍ଚଳ ମହିଳାମାନେ ଆବେଦନ କରିବେ ଗାନ୍ଧୀପଡା ଶଙ୍କର ମେହେର ଘର ଠାରୁ ରବି ମେହେର ଘର ପର୍ଯ୍ୟନ୍ତ.
All right.
But kindly have a glance.
So your what happened then?
Madam, also please see page 10. Clause 1. ଆବେଦନକାରୀ କେବଳ ମହିଳା ଶ୍ରେଣୀ ସମ୍ପୃକ୍ତ ଗ୍ରାମର ସ୍ଥାୟୀ ବାସିନ୍ଦା ହୋଇଥିବା ସହିତ ସମ୍ପୃକ୍ତ ଗ୍ରାମରେ ବସବାସ କରୁଥିବେ. The same movement just contrary to each other, madam. In one way, they are fixing a area where from the person can apply, but other not the advertisement says each and every person. There is one.
We will have to refer to the rules or the guidelines. You can also refer to.
And this aspect, thereafter, madam, in the next advertisement, yes. Let us accept.
No. Let me complete. This Tikrapada 3 was the Anganwadi center. The area was Gandhipada. From this house to this house. So where was she residing? What happened? What happened to this? What happened to this advertisement? You submitted your application.
Yes, I have submitted.
You were rejected.
No.
Then
because at the time of scrutiny, my lord may see page annex 3, page 18.
Yes.
Amongst all, my lord, my name is appears in the first.
লেখা আছে অঞ্চল পরিসর ভুক্ত
প্রমেয় কুমার আজ্ঞা
অঞ্চল পরিসর ভুক্ত তো লেখা
আছে.
So what happened?
তারপরে ସେମାନେ କଣ କଲେ କ୍ୟାନ୍ସେଲ କରିଦେଲେ.
କୋଉଠି କ୍ୟାନ୍ସେଲ କଲେ?
So
ଆଉ ଗୋଟେ ଆଡଭର୍ଟାଇଜମେଣ୍ଟ ବାହାର କଲେ.
ଆଜ୍ଞା.
Then thereafter, my lord, in annexure, they have filed it as annexure A/5, my lord.
Yes.
In our counter.
Copy of the proceeding.
Counter again.
Yes.
What do they say?
Lordship may peruse that.
Tikrapada. For this, Anganwadi 3 number of candidate applied for this. They are Pamela Kumar, Geeta Dev, nobody belongs to the service area Tikrapada, meaning Gandhipada area. So this is the ground.
Yes, ma'am. And accordingly, my lord, it was
So
decided.
whether she belongs to that Gandhipada or not, that is the only thing to be found.
Yes, ma'am.
What did you find out?
My lord, initially, my lord, when this particular decision they took, my lord, at that point of time, my lord, they found that nobody is belonging to that Gandhipada area. So, since none of the and this is belonging, this is for the process of mini Anganwadi center. Strictly, my lord, it is to be followed with respect to that service area. Had it in a case of Anganwadi, my lord, then the case of the entire village that could have been taken into consideration. In this case, my lord, since it is a case relating to mini Anganwadi center, that is why, my lord, unless and until the person any of the person, my lord, is found to be of that particular service area, the selection procedure was cancelled.
So, but this is not very clear. She simply says that nobody belongs to that area.
Yes,
Ki
ma'am.
କୋଉ area କୁ belong କରୁଛନ୍ତି ତ ଦେଖେଇକି କରିଥିଲେ ହେଇଥାନ୍ତା. Anyway, what does the inquiry say?
Now, my lord, they are saying that, my lord, in the year 2023-24, my lord, the affidavit what we have filed, my lord, just now. My lord, there was a direction to
Inquiry and submitted an inquiry report on.
Annex of C by 5, my lord, maybe.
Let me see the inquiry report. Hold on.
Annex of C by 5, page
Page,
number 18, my lord.
see, it is there, my last page, my lord.
18.
Page, yes, my lord, page 18, my lord. 1-8.
କଣ ଲେଖା ହେଲା? ଅନୁସାରେ
Decision
ଟିକରାପଡା ଗାନ୍ଧୀପଡା ମିନି ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ରକୁ ଚାର୍ଜରେ ଥିବା ଅଙ୍ଗନବାଡି କର୍ମୀ ଶ୍ରୀମତୀ ଲିଲି ଝାଙ୍କରଙ୍କ ସହିତ ତଦାରଖରେ ଯାଇ ଗ୍ରାମବାସୀଙ୍କ ଠାରୁ ବୁଝିବାକୁ ପାଇଲୁ ଯେ ଶ୍ରୀମତୀ ପ୍ରମିଳା କୁମାର ସ୍ୱାମୀ ବମ୍ବେଶ୍ୱର ଦୀପ
ବର୍ତ୍ତମାନ ସ୍ଥିତି ଉପରେ ଗ୍ରାମବାସୀ କହିଲେ ଯେ ସେମାନେ କେନ୍ଦ୍ରାପଡା ଟିକରାପଡା ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ର ପରିସର ମଧ୍ୟରେ ରହୁଛନ୍ତି ଏବଂ ଟିକରାପଡା ଗାନ୍ଧୀପଡା ମିନି ଅଙ୍ଗନବାଡି ଯୋଉଟା ଏଇ ବର୍ତ୍ତମାନ ଏରିଆଟା ଅଛି ପରିସର ଆଜବେଷ୍ଟସ୍ ଘରଟି ଅଛି। So we are having a
ମାତ୍ର
house.
ସେମାନେ ସେଇ ଘରେ ରହୁନାହାନ୍ତି।
They are outside and
ସେଇ
also.
ରହୁନାହାନ୍ତି ମାନେ ସେଟା 2024 ର କଥା ଆଉ।
ମୁଁ ତ ସେଇଆ କହୁଛି exactly
That is what, my lord,
in my
should appreciate that because this is a direction where the inquiry was directed to be conducted in this manner, my lord. So this is the report, my lord.
We consider
With respect to the previous one, my lord, we do not have any other record.
ତାହେଲେ how can you justify?
Some records were there, my lord, because none of the 3%, my lord, who had applied for the post, they belong to that particular area. So that is why, my lord, it has been
But
rejected.
now this inquiry, this does not say that they have moved to Gandhipada
Yes, ma'am.
recently. ସେ କଥା ତ କହୁନାହାନ୍ତି ପାଇଲୁ ଯେ ଅମୁକ ସ୍ଥିତି ଉପରେ ଗ୍ରାମବାସୀ କହିଲେ ଯେ ସେମାନେ ଟିକରାପଡା ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ର ପରିସର ମଧ୍ୟରେ ରହୁଛନ୍ତି
Again.
ଏବଂ ଟିକରାପଡା ଗାନ୍ଧୀପଡା ମିନି ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ର ପରିସର ମଧ୍ୟରେ ଆଜବେଷ୍ଟସ୍ ଘରଟି ଅଛି ମାତ୍ର ସେମାନେ ସେହି ଘରେ ରହୁନାହାନ୍ତି ସେଇ ଘରେ ରହୁନାହାନ୍ତି ମାନେ ବର୍ତ୍ତମାନ ରହୁନାହାନ୍ତି ନା ଆଉ।
Again.
So it means they have some presence in that Gandhipada. It cannot be denied.
area of operation.
What do you say?
My lord, these are the records before your lordship.
No, I don't think.
Now, what is the report? What it was actually taken into consideration by the sub-collector at the time of.
So let
proceeding
them,
and unnecessary-
let the selection committee. I will quash that portion. I'm just proposing. I'm just thinking aloud. I'll quash that portion. I'll say that in view of this report, you consider it again. You find out. Consider. ଆଉ ଆପଣଙ୍କୁ appointment କଣ ଦେବା ପାଇଁ କୋଉ select ହେଇଥିଲେ କି ଆପଣ? Were you selected?
Selected ତାକୁ ତ ମୁଁ ସେ ଅଟୋମେଟିକ ମୁଁ ତାକୁ ତ I'm the befitting candidate.
So every candidate will say that I am the
Admittedly.
କିଏ admit କଲା? Who admits?
Documents are with
Document କହୁଛନ୍ତି ସେ ଆପଣ you are the protection.
I have secured the highest mark.
So you are afraid of fresh selection. So let them consider it.
Yes.
That on that subsequent advertisement जाओ. But the original selection process that was stopped midway on the ground that none of them belong to the service area. But it does not specify.
Yes.
It does not is very non-speaking. In view of this inquiry report, which privacy shows that she is a resident of that Gandhipada, does it not?
At least vis-a-vis that Annex 3, page number 18, as your lordship pointed out, where the CDPO, the then CDPO, had specifically indicated that
So we can say that you continue with that selection process and find out whoever is. But if, because at the relevant time, when the CDPO says that they were Anchola Porisara Bhukta. No, this is on the basis of the verification of the certificates, not on the basis of an inquiry. So they claim all the candidates, they claim to belong to that Tikrapura.
Gandhipada. Yes.
Tikrapura Gandhipada area. So that becomes a little bit, because if you look at that rejection order, it is non-speaking.
Yes.
Completely non-speaking.
That cancellation document.
Yes.
Yes.
Now more so, in view of the recent inquiry that has been conducted, which privacy shows that, so let them consider it. Let them consider it. It shall be open to them to consider, also take into account their status. Where they are residing?
Lordship message.
All right. The petitioner has approached this court with the following prayer. Para. The facts of the case, briefly stated, are that an advertisement was issued by the CTP of Virmarajpur in the district of Sonpur, Subarnapur, on 19/11/2012, inviting applications from eligible candidates for their engagement as Anganwadi workers in several Anganwadi centers and mini Anganwadi centers. Pursuant to such advertisement, the petitioner submitted her application for कौन सा था? कहीं से रखो जगह ने? 18 day ना para 16 day. Who ऐसा देशन देखिए. ये just now you were showing.
And again, there is an additional affidavit.
ना इधर page के थे.
Page टा होची 13 14
page 10
16 आगे
16
page 16 of my writ application.
yes page 16 serial number
again Gandhi Tikrapura 3 again
serial number कहीं
serial number 7
serial number 7 is
Subbolaya Tikrapura
Tikrapura
Gandhipura 2 sir
for Tikrapura 3 mini Anganwadi center. Stop. As per the advertisement, the service area of Tikrapura 3 mini AWC was Gandhipura, and from the house of one Shankar Meher to the house of Ravi Meher.
again
Stop. The in all three candidates had submitted their applications for the said mini Anganwadi center in all. Stop. The CTPO, after scrutinizing the applications, found all of them to be residents of the service area. Stop. The selection committee,
page
selection committee,
page 7
in its meeting held on 26/10/2016, however, found that or held that all the three that none of the candidates belong to the service area of Tikrapura mini Gandhipura AWC area. As such, a decision was taken to re-notify the mini Anganwadi center. Pursuant to such decision, a fresh notification was issued by the CTPO on 3/11/2016, which is impugned in the present writ application.
page 5
The petitioner claims that she is a resident of.
I will just have a glance to page 23. There also the house Shankar Meher, which was there for Shankar Meher to another marriage has been also changed. And this Gandhipura, it has also been changed, Madam. There Tikrapura 3. Now they have said Gandhipura, Tikrapura, Shankar Meher Ghar tharu Shibo Meher Ghar porjont.
Answer कौन सा लगी? Shankar Meher Ghar tharu Ravi Meher Ghar जाए. Chalo. The petitioner claims to be a resident of Gandhipura, coming under the service area of the mini AWC. In course of hearing, by means of an affidavit, it is stated that the petitioner was staying with her husband and in-laws in a thatched house after her marriage, which was subsequently converted to an asbestos house at Gandhipura. After residing there for 6-7 years, a new house was constructed by the side of Gandhipada, to which the petitioner and her family has shifted. An additional affidavit has been filed by the state, wherein it is stated, wherein the following is stated under paragraph 5. On perusal of the inquiry report, as referred to in the above paragraph, it is seen that the inquiry revealed that the petitioner was in fact a resident of Gandhipada, and that she also has an asbestos house therein. Asbestos house there, though no one is residing there. There is no dispute that the said house comes within the service area of Tikarapada 3 mini AWC.
It's for the advertisement.
As per the advertisement. Sriji Manas Chand, learned counsel for the petitioner, would argue that this prima facie shows that the petitioner belonged to the service area of the Anganwadi center in question, and therefore therefore the selection process could not have been cancelled and a fresh notification issued. Siyasan Patnaik learned AGA, referring to the inquiry report, submits that though there is an asbestos house within the service area, yet no one is residing there. And therefore, it cannot be definitely said that the petitioner is a resident of the service area. All right? Yes. Stop. After considering the submissions and on going through the documents enclosed to the writ application, this court finds that there is prima facie evidence that at least during the time of selection, the petitioner advertisement and selection, the petitioner was a resident. This is a prima facie view. A resident within the service area of the mini Anganwadi center. Stop. Such fact finds support from the inquiry report filed by the state. Stop. Under such circumstance, furthermore, the perusal of the proceedings of the selection committee meeting reveals that reveals that it was somewhat mechanically held that nobody belongs to the service area without specifying as to which place the candidates belong, if not the service area. Stop. This is being said in view of the report of the CTPO, in view of the what is this? Annexure 3, what can we say? What can we call it?
Annexure,
Annexure 3, joti CDPO କହିଛନ୍ତି. In view of the specific endorsement made by the CDPO.
well, that is the inquiry report.
No. Annexure 3 is not the inquiry.
Oh, Annexure 3, my lord, that is notice, my lord.
In view of the endorsement made by the CDPO in the document,
Notice inviting objection. my lord.
in the notice dated 9/2/2016.
Yes.
Inviting objection.
Yes.
That all the three candidates belong to the service area. So, the finding of the selection committee, therefore, appears to be erroneous. Under such circumstances, inviting, going for a fresh notification seems unjustified. But for the foregoing reasons, therefore, this court is of the view that there is some prima facie evidence to show that at least the petitioner was a resident of the service area at the relevant time. In such view of the matter, the decision of the selection committee to go for fresh advertisement cannot be sustained. The writ application is therefore allowed. The impugned notification dated 3/11/2016 is hereby quashed.
With respect to that, many Anganwadi center.
Is quashed only insofar as it relates to Tikrapata 3 mini Anganwadi center. Stop. The sub-collector, na? The sub-collector, Subarnapur, being the chairman of selection committee, is directed to consider the three applications, including that of the petitioner, received pursuant to the original advertisement dated 19/11/2012, and to take a decision regarding selection of one of them regarding selection of the most suitable candidate among them. Stop. In doing so, it shall be open to the selection committee to consider the present residential status of all the three applicants. Stop. The whole exercise should be concluded by completed within a period of 4 weeks.
Yes.
Within a period of 4 weeks from the date of production of certified copy of this order by the petitioner. Yes.
One prayer. While considering that aspect, but the inquiry report, present inquiry report will consider.
All right. It goes without saying that it goes without saying that that the selection committee shall take into consideration the inquiry report dated kete
Sir, Annexure 3/5.
date
5/6/2024.
3/6/2024 submitted by
Mandala Paridarshika.
lady supervisor. No, area supervisor.
Obviously. Mandala zone for it's for
Annexure 3/5.
The inquiry report, copy of which has been enclosed to the writ application as annexure C/5.
C/5.
Additional application.
Copy enclosed to the additional.
Indicated matter is indicated the date.
Item number 10.
Item number 10, I am a PC. I'm little unwell today. I may be allowed to assist your lordship through PC.
Yes,
Am I audible to my lords?
yes, loud and clear.
My lord. So grateful, my lord. The pursuant to my lord's earlier orders, they have come up with an instruction, copy of which was served on me also. I have verified that instruction, which is not in terms of orders passed by my lords. Before I take my lords to the merits involved here, I'll just request my lords to see that order wherein your lordship has in fact pinpointed the issue. That is order dated 10th of February 2023, order number 10. Would the lordship like to see that? May I permitted to read it, ma'am?
Yes, yes.
This matter is taken up through hybrid mode, hard in part. It is submitted by Mr. P.K. Rathal and counsel for the petitioner that as per notification dated 30th of April 2016 and
It should have
access.
been senior counsel, wrongly learned counsel age. The order dated 15 to 2023, the word senior.
Might not be, my lord. By then I was not. I became senior counsel in the month of July.
Oh, July.
Yes, your lordship is correct.
All right, all right. ठीक है.
Right, my lord.
All right. Why the 2023 order?
Right, my lord.
Oh, yeah. Okay. Please continue.
It is submitted by Mr. P.K. Rathal and counsel for the petitioner that as per notification dated 30/4/2016 and Excel 7, the fifth preference candidate was required to appear physically on 5/5/2016 at DPO SSA Balashore along with all original certificates. It is his further allegation that only 8 candidates appeared on the date fixed, among whom the petitioner was placed at serial number 4 in view of the marks obtained by him in paragraphs 10 and 11 of the writ petition. This fact has been stated but not replied to specifically in the counter affidavit. It is further submitted by Mr. Rath. Even the candidates who are shown to have been selected have not actually joined, and therefore there is availability of vacancy. So P.K. Pandal and additional and standing counsel for the school and mass education directed to obtain instructions and also to submit reply specifically to the amendments made under paragraph 10 and 11 of the writ petition. At least this matter. But thereafter they have been taking prevaricating stance. Now let me take my lords in a nutshell and quickly what is the issue about. Because I like not to linger the matter further. It is lingering since long. Lordship may kindly see the advertisement first, page 29. Page 29. Page 29 of my.
Yes.
Lordship sees the exact vacancy position in respect of Balashore district at page 31. Serial number 2 is the Balashore. Lordship got it?
Yes.
Page 31.
Yes.
We are concerned about TGT Arts. Total vacancy indicated 226.
226, yes.
I am concerned about that I have applied page 32. This is my application. At serial number 8, I have indicated the category only as ACBC. Serial number 8. But you got it?
Yes.
But law, my lords, is aware that irrespective of the fact that someone is SCBC or SC or SC, he is first to be considered against general. In terms of merit, he comes under the category of general. Then obviously he will be fitted against the general. Thereafter only, as a 97 Supreme Court other judgments are there. It's settled position of law. Now, my lords, we kindly see page 23. Page 23. But here your lordship will find, sorry, I am so sorry, page 33. I am extremely sorry. Page 33.
Yes.
Here, my lords will find total TGT your vacancy is 5. At the top only. Number of posts, you are 5. Right. Now, as against this 5 your TGT posts, they called candidates for verification of their documents. That is, that letter is at page 42. 42.
Yes.
But you may see the candidates were called to appear physically and get their documents verified. It is hereby notified for information of all concerned. Pursuant to advertisement, so-and-so dated, so-and-so dated, so-and-so. State Project Director Office of Bhubaneswar, the candidates who have opted Bhubaneswar 5th preference district, including second preference over age candidates for engagement of Sikha Sahib, draft merit list, including number of vacancies in respect categories of Bhubaneswar district hereby published. The district-wise, so-and-so, so-and-so. The candidates are instructed to file objections if any details also. Last date for filing objection is 5/3/2016 5 p.m. During working days only. The verification of original documents and certificates of the candidates should be held on 5/5/2016 7 a.m. in the violation. Am I clear, my lord?
Yes.
The candidate will have to bring original certificate along with a set of self-attested photocopies. Means candidates have to physically come and bring these documents for verification. Now, as against this 5 vacancy, they had called 39 people. As against these 39 people, altogether 8 people, they verified their document. 8 people, 8 candidates, they verified their document, and among those 8, I was 4. Now, what they have done, they have issued appointment order just to the next page, page 40. Page 40. They have issued appointment order in respect of these 5 persons, top 5 persons, page 43.
Yes.
These people have never attended verification nor have produced certificates for verification. So if these 5 people have never appeared for verification, that is what my specific statement on affidavit for this honorable court, and your lordship has taken note of that in that order which I have read. So if these people have not come for verification, and out of 8 persons who have come for verification, I have serial number 4, I should have been considered. So instead of that, now they have given that instruction that SCBC vacancy is 0. Therefore, I was not engaged in view of my percentage.
Where is that written instruction? Last time did you file it?
Yes, yes.
Okay.
Yes, copy has been submitted.
File it.
They are not replying to the query raised by my lords. Again, they are trying to confuse the issue with reference to SCBC. SCBC is not the issue at all.
No, CBC will come later. First, no, general merit list is to be prepared. Isn't it, Mr. Das?
Yes.
Generally, merit list a person may belong to SC, ST, SCBC, doesn't matter. But he can compete on merit.
Yes.
There is no stopping him.
Yes.
You cannot stop a person from competing on merit, and that is the law.
They should clarify and say that whether these 5 persons have attended verification. They are not replying. In the counter, kindly see, madam. What are they saying? Counter.
You have another copy?
Yes.
Of that written instruction?
Yes, yes.
Page 3 of their counter, kindly see. Para 7.
Yes.
Kindly see page 3, para 7. That it is humbly submitted that 8 numbers of candidates have verified their original document certificate on 5/5/16. Total vacant post 5, 5th district including secretary of age candidate. The engaged candidates category 5th preference have secured these persons. Jagabandhu, Alok, Manas, kindly see. It is pertinent to mention here that petitioner secured 161, which is marked less than. But they are not replying whether these 5 candidates have verified their documents physically and whether they have joined. No. Which I have categorically taken a stand.
But how can this court now come to a finding in this regard unless they come up with an affidavit?
So they are not. They are avoiding it. That's the point I'm saying. But can it be made so that in view of my statement, your lordship has already clarified the last offense on that unless they clarify this matter will be decided on its own merits. That order is also passed by my lords. Kindly see. Kindly see, my lord. Then your lordship has also passed an order. Yes, ma'am. Order dated 7th of May 2020. Order number 11.
No, I need to find out. You have said that he belongs to SCBC category.
Yes.
And since there was
by the time his 5th preference, that is Balesur district, was considered, SCBC was filled up.
SCBC may have been filled up. SCBC may have been filled up. But what about the general merit? That you have to clarify. That you have to clarify so that this court can take up the matter in the right perspective.
In the unreserved category.
In the unreserved category. He and another allegation being made by Mr. Ratha is that they
were not present.
They were never present. 8 persons were present, out of whom he was the 4th.
Yes.
He should have been given.
So if he was 4th in the order of merit of those 8 persons, and he secured whatever percentage, then he should have been given. That is his case.
But they have now the instruction stands as if he is belonging to the SCBC category.
No. I will ask you to find out again. You have to answer this.
Yes.
Also,
Your lordship makes
yes.
the order specify, yes.
Yes, Mr. Ratha, I'll ask him to specify this.
My lords, please.
I'll record your submissions.
Correct.
Heard further arguments and part. In course of hearing, Sri P. K. Rathalan and Senior Counsel appearing for the petitioner specifically, categorically contends that the that pursuant to, where is that notice?
Page 29.
Pursuant to the notice dated 30/4/2016, bracket annexes 7, 8 candidates, including the petitioner, had appeared for their document verification,
Yes.
of whom, the petitioner was 4th.
Yes.
The candidates shown in the final list under the UR category, according to Sri Ratha, had never attended the physical, had never attended, had never appeared for physical verification of their documents.
Nor have joined also.
Yes. It is further submitted that the petitioner, though belongs to the social category SCBC, yet he cannot be debarred from being considered
Yes.
on merit as a general candidate.
As against your vacancy.
General candidate.
Yes,
General,
that will.
general candidate. The written instructions furnished by London State Council is to the effect that there were no vacancies in the SCBC category for which the candidature of the petitioner could not be considered. Stop.
By the time his 5th preference district.
For the 5th preference district.
SCBC is all throughout 0.
This court would like to know whether the petitioner was considered in the general list of all candidates, irrespective of their social categories,
as per his merits.
As per merit.
Among the candidates who appeared for verification.
Further, this court would also like to know whether the submission of this court would also like to know the response of the state to the submission of Sri Ratha that the 5 candidates mentioned in the select list prepared on 6/5/2016 under the UR category had actually had physically appeared for document verification or not.
Yes.
Specific instructions in this regard shall be obtained by the State Council. List this matter on 1st August 2020.
Copy of the order.
The free copy of this order be handed over to London State Council for compliance.
I don't know, 11. I have one more prayer.
Yes.
I have 1 or 2 second appeals today. But if I am not able to attend, kindly accommodate me till next week. I'll argue.
I am filing an additional counter affidavit. The government advocate did not produce the record and also did not file any counter.
Last time.
For that reason, the last occasion I have
already filed the counter.
Subsequently additional. Additional say our document mistake gotae कर दीजिए. आरटाକୁ not press कर दीजिए. କାହିଁକିନା ସେ document ସେ ବହୁତ କହିଲା ପରେ ବୁଝି ପାରୁନାହାନ୍ତି ସେ ଲୋକ. ଏଠୁ ଆଣିକି ଦେଲା ବେଳକୁ
Sri Mahanti, Learned Counsel appearing for private opposite party, files another additional counter affidavit and submits that the previous additional counter affidavit be ignored.
Yes.
Let a copy of the affidavit filed today be served upon the other side.
Yes.
Lordship, only I pray, Lordship, last time it was reserved for judgment. The last moment additional counter was.
Next week, yes. List this matter next week.
Hostel, Lordship.
Next week, can I say?
1 week up.
Item 28. 1st August. Yes.
I don't know, 12.
petition as a prayer for a reader scale with effect from 1/8/98.
What about your counter?
Well, you filed on 16/7, but I'm submitting it.
Learned State Council files the physical copy of the counter already e-filed.
On
Can
16/7.
be kept on record. Yes. You have received the counter today or earlier?
Today, my lord.
Today.
Would you like to argue? Would you like to argue today, or you like to go through this counter?
To go through.
Yes. Is this matter on 1st August?
Partially, I have supported his case.
Item number 13.
My lord, in this case, my lord, there was a direction to conclude inquiry by the collector of Baleshwar, my lord. And thereafter, my lord, there was some modification of the order even, my lord.
To grant
To
opportunity of
grant the
hearing.
opportunity of hearing.
What happened to the?
I have not received any instruction. This may be taken up next week, my lord. Today in the morning, my lord, I had contacted with the DSW. And in fact, my lord, on personal health ground, my lord, actually she had requested me to take it to next week, my lord, so that I can get the operating instruction.
All right. Learned State Council requests for an adjournment.
Yes.
On the ground that he has not obtained the required instructions. Is this matter next week?
Yes.
But it will come on 25th.
Yes.
Item number 14.
My lord, on last occasion, opposite partner number 5 had taken time, my lord, for filing of counter, and they already filed the counterman. Let them file counter copy, my lord.
No, last time
My
on
lord,
1st July it had come. You wanted to file rejoinder.
my lord.
You wanted to file rejoinder.
My lord, in this case, my lord,
Are you filing rejoinder or?
no, he has filed
petitioner, yeah.
the journal, my lord. And I have filed to already the counter affidavit. I am appearing on behalf of opposite partner 5, my lord. I have filed counter affidavit. And also counter filed to
It's
the
not on record? Your counter affidavit is not on record?
filed on 12/7,
12/7 ଆସି ନଥିବ?
12/7.
We'll tag it. Last the office to tag the counter. There is nothing record. ଏଥିରେ ନାହିଁ ମାନେ ମୋ scanned copy ବି ନାହିଁ. Counter is of opposite party 2 to 4 is there.
Yes.
Copy not served, my lord. Opposite partner number 5.
Serve copy.
I'm sorry.
ଅଛି ବେଶ ଦିଅ ତାହେଲେ hard copy ଦିଅ. Physical file ଟା ଦିଅ. ଅଛି? ଏ ଦେଖେଇନି ଆଉ. ହଁ ଅଛି ଅଛି. ଠିକ ଅଛି. Yes.
Yes, my lord. Already my copy served, my lord.
Yes.
It may be taken up first.
Copy of the counter affidavit filed by opposite party number 5 is served on counsel for the petitioner who wants some time to go through the same. List this matter on 1st August.
Item 15.
My lord,
Interim order to continue.
The outside one, I'm sorry, I have not filed the requisites to send notice to the opposite party number 4, who is in the meantime, my lord, engaged as the Anganwadi worker, my lord. I may be permitted to do all such things.
There is no such order. Was there any order?
That notings is there, my lord. Noting is there. In course of the day, I do all. Because
The Grand Learned Counsel for the petitioner undertakes to file the requisites for issue of notice on opposite party number 4 in course of the day. Peremptorily. Telling which the matter shall be dismissed without further reference to the bench. 2018 ଆପଣ ନିଜ ଭାଙ୍ଗୁନି. You are changing the line of your practice maybe.
Yes.
With all blessings of my lord.
Peremptorily.
It requires the blessing of my lord.
Notice be issued as directed earlier, fixing a short returnable date. Is this matter?
9th August.
হ্যাঁ আর কি করবো
11 September.
না না 9th August তুমি বলছো তো 29th August বলে 29th August
I don't know, 16.
rejoinder রাখতে land council of the petitioner files the rejoinder in court same
written notes bargo.
written note কোন হচ্ছে কোন you have received copy
Yes, sir.
yes
The matter before lordship.
Before proceeding. I have already filed a counter on 6/12/2023.
no your counter is on record
That is, I'm just serving the High Court.
Land State Council also files physical copy of the counter affidavit earlier filed by him same he also kept on record yes
Matter before lordship. The appointment of an Anganwadi worker in Ektali Anganwadi center. Before going that, before this writ petition, there are 2 writ petition has already been filed by the opposite party number 5. Selection process, the petitioner before lordship is selected. Challenging the same, the opposite party number 5 has filed an writ application before this honorable court. This honorable court directed to file an appeal. Appeal filed, appeal allowed. The appeal dismissed by the learned ADM. Thereafter, again, the opposite party number filed an writ application. This honorable court has remedied back the matter for fresh adjudication. Before this, the challenging the order passed by the.
here another appeal order is here impugned
Yes, sir.
which order then
Under Annex 8.
ତ remit ହେଲା ପରେ
Annex 8 ଟା ଆସିଲା.
so it was allowed the appeal was allowed in favor of the private opposite party
Yes.
yes so that is why you are now challenging
Yes, sir.
all right Annex 8 what are the facts
Actually, your lordship, from the initially, the opposite party number 5 has not belongs to the Anganwadi service area. Her claim that he would get, she should get a extra 5 marks as an ECC worker. In appeal, the learned area found that the opposite party number 5 was working as ECC worker in another center. In that village, there was also advertisement for Anganwadi center. The Mangor ECC center is ECC worker भाବରେ काम करते ତେଣୁ ସେ ଏଇଟାରେ ଆପ୍ଲାଏ କଲେ ଯେ ଆମେ ସେଠୁ 5 ମାର୍କ ଏକ୍ସଟ୍ରା ପାଇଲେ ଆମେ ହାଇଟ୍ ମାର୍କ ପାଇବୁ କିନ୍ତୁ ସିଲେକ୍ସନ କମିଟି ତାଙ୍କୁ ଦେଲେନି ସେଇ ଗ୍ରାଉଣ୍ଡରେ ଯେ ସେଇ ଅଙ୍ଗନବାଡି ନା ମାନଗଡ଼ ଇସିସି ସେଣ୍ଟରରେ ସେ ଥିଲେ ଏକତାଳି ଭିଲେଜ ଏକତାଳି ଭିଲେଜର ଗୋଟେ ମଧ୍ୟ ଇସିସି ସେଣ୍ଟର ଥିଲା ସେଇ ଇସିସି ସେଣ୍ଟରରେ ସେ କାମ କରିନାହାନ୍ତି 3 ବର୍ଷ କାମ କରିଥିଲେ କିନ୍ତୁ ଏଇ ଇସିସି ସେଣ୍ଟରରେ କାମ କରିନାହାନ୍ତି ସେ ବିଲଙ୍ଗସ୍ ଟୁ ମାନଗଡ଼ ଭିଲେଜ and working as ECC worker under the Mangod.
So this is the point. Yes, Mr. Patnaik, what is the stand of the state?
Lordship, may come to page number 35.
Yes, 35.
My lord, that is the impugned order, my lord. The appellate authority has framed certain issues, my lord. That is 1, 2, 3, 4. And accordingly, my lord, he has answered it. So, my lord, with respect to this annexure 8, that is document. The issue with respect to that, whether that particular Mangod village, the ECC center where the opposite partner who got selected, whether she had served there and that is to be taken into consideration or not, that has been answered in very fast parameter. And Answer 8 is a report of the Tahsil Josipur, wherein the Tahsil has stated that Mangod is not a revenue village, it is a hamlet Shahi under the revenue village actually. Therefore, it can be safely concluded that Mangod is not a revenue village and the appellant who worked as ECC instructor in Mangod under Ektali revenue village. On the question number 3, it is found that the appellant has requisite experience as ECC instructor at Mangod and the headmaster Ektali UGUP school has issued requisite certificate to Padma Kondagel.
Opposite partner 5.
Yes, Kondagel. which forms part of the material evidence produced by the appellant. On the point number 4, that is entitlement of marks to the appellant, it may be stated that answer is yes.
No. You produce the notification of establishment of that ECCE in Mangalore.
Yes.
You want to know the area which it was.
I have also annexed, you will also kindly see a running page 39. Running page 39, annex 12. Lordship got it?
Yes.
The revised the guideline 16/6/2010.
Yes.
I am direct last part, Your Lordship. The DSW Bhadrak, the sub clarification regarding admissibility of ECC certificate issued by the NGO. Sir, I am direct to invite the representative subject side to clarify that as under the experience certificate issued by an NGO to an ECC worker will not be accepted for Anganwadi worker selection. Next part, Your Lordship. An ECC worker can be considered for selection as Anganwadi provided. Anganwadi worker provided that she had worked as ECC worker in that particular Anganwadi center. On the basis of which the first appellate authority has dismissed the appeal under Annexure 7, Your Lordship. I have also annexed under Annexure 7. The order passed by the
Appellate authority in the first time.
first appeal.
This is in total contradiction to the previous order.
Yes.
Previous order.
So this court would like to know
Yes.
the notification establishing a ECC at Mangalore. Since it is not a separate revenue village, it's a hamlet.
Yes.
Yes,
So the ECC must have been issued to cater to the needs of a particular hamlet.
Yes.
So there, coupled with this guideline which Mr. Behra has just now referred to, I would like your specific instruction. And what are your preliminary submissions, Mr. Mishra?
Well, because there is no irregularity or illegality in the Annexure 8 that the order passed by the ADM Morgans. I have also filed the counter affidavit wherein it has been specifically stated by the Tahsildar that Mangad is a hamlet and Sahi that comes under the Revenue Village Act.
No, but there are two ECC.
Yes, Your Lordship.
Maybe, my lord,
Two
because,
ECC.
but as per the
There are two
circular-
ECC.
Yes.
One ECC is for Ektal and another ECC is for Mangalore.
Mangalore.
Yes.
Isn't it? So this court would like to know
Yes.
the area of operation of ECC under Mangalore. If it is for the entire revenue village, you have a case. If it is not, then there will be difficulty.
I have also annexed the voter list, Your Lordship.
Number voter list over.
Again,
This court
report
would like,
again.
yes, Mr. Patnaik.
Yes.
Particular CDPO report ଅଛି CDPO report ଦେଇଛନ୍ତି ଯେ ମାନଗଡ଼ ଅଙ୍ଗନବାଡି ସେଣ୍ଟର ଅମୁକ ଅମୁକ ଏରିଆ ଆଉ ଏକତାଲିଟା ଅଙ୍ଗନବାଡି ସେଣ୍ଟର ଅମୁକ ଅମୁକ ଏରିଆ
That is true. That is true.
Your Lordship, may kind Your Lordship, kind attention Your Lordship. Notification order Annexure 1 running page 14
That I will consider. That I will consider.
paragraph 3 तीन पॉइंट रे से कहले जे सिलेक्शन ऑफ पर्टिकुलर अंगनवाड़ी सेंटर सर्विस एरिया हेतिवा दरकार पॉइंट नंबर 3 Your Lordship, प्रार्थिनी जो अंगनवाड़ी केंद्र निमंते आवेदन करिवे से सही केंद्र सेवा अंचल रे स्थायी बासिंदा होइथिबे एवं उक्त केंद्ररु समस्त सेवा पाउथिबे that the
Before taking a final decision, this court would like to see that ECC notification. Establishing ECC that center in Mangalore.
Yes.
I'll keep it part heard. Heard in part. Since the appeal preferred by the opposite party number 5 before the ADM was allowed on the ground, internally on the ground, that the opposite party number 5 was a ECCE volunteer under Mangad ECCE, which comes within the, which is not a separate revenue village, but a hamlet under Ektali
revenue village.
This court would like to peruse the notification establishing ECC at Mangad.
So also at Ektali, my lord.
So also at Ektali.
So that it will clear the.
Then State Council is directed to produce the notifications for perusal of the court list this matter on 1 तारीख परोटा हो 8th August.
Yes. Item number 18. But I was under the impression that this is governed by the new guideline. In fact, it is governed by the old guideline.
Old guideline?
Yes, sir.
2022 वाले तो old guideline है वो. New guideline came in 2023.
23. I verified.
What are you challenging?
And here I have challenged the selection of Anganwadi helper managers.
So I think appeal lies to the sub-collector, even under the old guidelines.
Yes, my lord. Under the old, here my lord, the appeal is filed before the appeal was filed before the ADM.
Okay.
And ADM has allowed the prayer of the petitioner, my lord, against which I have competition.
Where is that order?
Order under Annex 3, my lord. Sorry, Annex 5. It starts from page 22 onwards, my lord. Here, my lord, without selection, the opposite part number 5 has been directed by the ADM to be engaged as Anganwadi helper. I am permitted to place, my lord.
Yes.
The case is taken up today.
No, pura ta kahin
Again.
Pura ta kahin padu.
Be important, my lord. The case is taken up today. Advocate for the appellant is present and filed Hajira. Had him. He has placed demand for appointment of his client in the post of AWH as only eligible candidate. CDPO both also present. Gone through the selection meeting proceeding. Copy submitted by the Child Development Project Officer both. It reveals from the document submitted by the CDPO both that the application was invited for the post of Anganwadi helper of village Dangopada AWC by notification number 188 dated 12/2/2021. But no such application is available. The CDPO has filed the counter. He has also not annexed the document showing that application was invited. Thereafter, my lord, with scheduled selection meeting to be held on 19/2/2021. But that advertisement was not, it was done surreptitiously, it was never brought to the notice of the general public. Thereafter, the qualifications were the candidate should be a resident of the village, the candidate should know, read and write, the age of the candidate should be 18 to 42 years as on 1/1/2021, the candidate should interested for engagement of helper. Fifth is preference will be given to helpless widow and unmarried girl who have more than 35 years. And the present petitioner is a widow, my lord. Then conditions were permanent resident certificate, proof of educational qualification, voter identity card, Aadhaar card, etc. The selection meeting for AWH for Dangopada AWC was held in the chairpersonship presence of CDPO board on 19/2/2021. They said that on 19/2/2021 the meeting was held. The supervisor is present, the health worker and the ward member of the village absent. In this meeting, admittedly, this health worker and the ward member of the village were absent. Though they are the key members, in their absence, the meeting cannot be held. Thereafter, my lord, the candidate interested for the post of AWH were present in the meeting and submitted their application, namely Basanti Ahmad, Sasmita Pradhan, Kuntala Mahakur, such and such. Their applications and the table is being prepared. It reveals from the competitive statement that Srimati Basanti Ahmad, wife of Ashwasthama Kalta, is the only candidate who have passed 10 pass matric certificate examination. There are 23 women of village were present in the meeting, out of which 19 women supported the candidature of Srimati Basanti Ahmad and 3 women for Sasmita Pradhan. But the key members were absent in the meeting, and they say that one member, Basanti, was the only 10 pass candidate, others were not. Qualification is not a criteria, and that is the candidature of Kuntala Mahakur rejected as she is not above 35 years, and the candidature of Sasmita Pradhan not accepted. As the women present not recommended in favor of any candidature, the meeting was postponed. Srimati Suryamani Naik, supervisor, Mursundi, has been directed for inquiry about the meeting held on 24/2/2021 by the village women by ICDS board letter number 319 dated 1/3/2021. CDPO board has issued notice for holding of meeting at Dangopada Primary School on 4/3/2021 at 2 p.m. along with the list of 70 women by their office number 320 dated 1/3/2021. peruse the letter of child development project officer, both received by letter number such and such dated 2/12/21. It reveals from the letter of the CDPO both that a meeting was held for selection of the post of AWH at Anganwadi Center, Dangpada on 19/2/2021 at 2 p.m. as per notification letter number such and such dated 12/2/2021. In the said meeting, supervisor, Musundi and health worker were remain absent. That is the inquiry report, madam. Gita Pradhan, supervisor, Teliband and Rosalind Mr. supervisor, Tolsanda remain present in the meeting. 23rd women of village present. 3 candidates who applied for the post of AWH, namely Basanti Omat, Sasmita Pradhan, Kuntala Mahaku, and in the said meeting, the duty and responsibility has been explained in the detail. Out of 3 candidates, Kuntala Mahaku is not eligible for the AWH as her age is not exceeding 35 years. The candidature of Sasmita Pradhan, wife of late Sananda Pradhan, was not recommended, supported by the women present as she was working as CRP of OLM. The candidature of Srimati Basanti Amat, wife of Asosthama Kalta, was supported by the women present, but some widow women not present. One Basanti Naik, a widow lady, has claimed for engagement. The present petitioner on 22/2/2021, Srimati Suryamani Naik, supervisor of Musundi, has been directed to inquiry about the reality of the matter by the ICDS number such and such, along with the supervisor Lakshmi Prasad. She has proceeded to the village on 4/3/2021, but the said woman could not hold the inquiry and the post of AWH not filled up. The post was not filled up. From the materials placed before me, the following have been noticed as regard to the documents submitted by the CDPO both. First, the name of Srimati Basanti Amat, wife of Asostama Kalta, was supported by the majority women present. But the matter was ignored by the CDPO, stating absent of health worker, ward member, and widow woman of village. Second, without consider the candidature of Srimati Basanti Amat, CDPO both has further ordered the inquiry of application of the letter period dated 22/2/2021 of Basanti Naik, who have not applied as per the scheduled date. Finally, the selection procedure could not completed for engagement of AWC. The selection was not completed. So from the materials, finding your notes kindly see. So from the material and facts narrated above, I am inclined to believe that the applicant Basanti Amat, wife of Asostama Kalta, is only candidate who have passed the matriculation examination. And as the majority women of village present supported her in the applicant, Srimati Basanti Amat is entitled for appointment as Anganwadi helper in AWC Dangapada CDPO. Both is directed to issue engagement letter in favor of the applicant. Well, my humble submission is, my lord, as per the claim of the CDPO, no notification was issued for selection of for meeting of Mahila Sabha on 19/2/2021. And when the petitioner came on 19/2/2021, in the meeting itself, the 2 key members were not present. So the meeting was, the Mahila Sabha was abandoned. Nobody was selected. Thereafter, when the people of the locality came to know about the selection, they represented to the authority. They represented the collector, they represented the district welfare officer. So the district welfare officer directed to conduct an inquiry. The inquiry being conducted by the my lord, the CDPO report was furnished indicating that the Mahila Sabha could not be conducted because of the absence of the 2 key members. Thereafter, the same CDPO issued fresh notification on 1/3/2021 convening Mahila Sabha on 4/3/2021. On 4/3/2021, the present petitioner submitted her application for consideration in the Mahila Sabha. While the matter stood thus, the selected one, the opposite party number 5, challenging the notification dated 1/3/2021, which was issued by the CDPO, approached the ADM, the appellate authority. The appellate authority, without selection of anybody, on the basis of only consideration that the candidate is having a matriculation qualification, which is certainly not the criteria, has directed for his selection. But my humble submission is, since no meeting was held, no selection was held, and the meeting was abandoned due to absence of the key members, the ADM had got no authority under law to direct for selection of a candidate who was not even selected. And number two is the ground on the basis of which he is being directed for selection is matriculation. And matriculation is not at all a criteria for such selection. Rather, there is a qualification that she must be a widow. A widow will given preference over other candidates. The present petitioner is a widow and she should have been given an opportunity for in the process of selection for such selection.
All right. Yes, state.
That is what the ADM has said. I cannot go beyond the order passed by the ADM in appeal.
No, the question is, the guidelines prescribe a procedure for
Yes.
selection. The only thing is that you have to show that the procedure was followed.
Yes.
He claims that the procedure was not followed. That
In
is-
fact, the CDPO has filed a counter affidavit stating that Mahila Sabha could not be held.
So that seals the fate, doesn't it?
Yes.
What do you say? You are who's private opposite party? Anybody? Notice was issued. No, private
Yes,
opposite-
notice
was sufficient. I thought he was appearing so.
Mine is the next item.
No, সেটা আগে দেখি তো নোটিশটা সার্ভিস হয়েছে না নাই that from opposite party number 5 after valid service. So this is only now
appearance.
we'll set it aside. We'll set it aside and direct them to consider afresh.
As you know,
And কেতে সেটা গাইডলাইনটা
guideline টা হচ্ছে
25/2007 না না সেটা হলো অঙ্গনওয়াড়ি ওয়ার্কার
76.
এটা হচ্ছে 24/11/97
না না না
গাইডলাইন ফর সিলেকশন অফ হেল্পার
অঙ্গনওয়াড়ি হেল্পার is 26/2010.
সিলেকশন 26 এটা অর্ডারটা হচ্ছে 24/21
তাহলে এটা 26/2010 টা
দুইবার 21
এরকম
পেজ নম্বর
this is in detail.
76.
Mr. Mishra, this is in detail.
yes madam I'm happy with it.
It supports your case.
Yes madam.
So why are you looking so sad? It supports your case. I'm going to allow your writ application. I'll set it aside and the petitioner.
Clause number 8.
Yes.
না না
The
clause
petitioner
number 8
Clause number 8.
has approved. No, again, clause number 8.
না না
Question number है proper notice inviting application should be made in the AWC.
সেটা তারপরে
Area is mentioning the age limit of
clause number 8
তারপর মহিলা সভা है clause number 8.
সে নিউজ আইটেম भी पब्लिश করে পেয়েছে
The petitioner has approached this court with the following prayer. The facts of the case are that that a Mahila Sabha was constituted on 4/3/2021 at Dangopada Primary School for selection of Anganwadi helper. Of
19/2/21
upon election 4/3/2021 at 2 p.m. Come to paragraph 3 of your writ application.
Fourth was second. That was the second Mahila Sabha. The Mahila Sabha which was abandoned was 19/2/2021. Thereafter, advertisement was issued on one.
That you have not mentioned anywhere in your writ application.
Yes, one. I have mentioned.
Okay, how? A Mahila Sabha was constituted, was held on 19/2/2021 for selection of Anganwadi worker, selection of Anganwadi helper of Dangopada Anganwadi Center. Said Mahila Sabha had to be abandoned because of absence of the block supervisor and health workers, as also for non-recommendation of the names of the widows of the village. Another Mahila Sabha was convened on 4/3/2021. Stop. The petitioner, being a widow and having 2 dependent children, along with the necessary qualification, applied for selection on 4/3/2021. The opposite party number 5 challenged the
Notice dated 1/3/2020.
Challenge the notice dated 1/3/2021. Calling for the Mahila Sabha
On 4/3.
before the ADM, both, which was registered as Miss Case number 1 of 2021. The petitioner also challenged non-consideration of her case by submitting a representation to the sub-collector both on 21/10/2021. Subsequently, having come to know about the challenge by the opposite party number 5, she sought to be included as a party in the proceeding before the ADM. It is alleged that no notice was issued to the petitioner, nor any opportunity of hearing was granted. Ultimately, the ADM, by order dated 2/12/2021, held that the opposite party number 5, being the only qualified candidate, ought to have been selected, and therefore directed the CDPO both to issue engagement letter in her favor. Stop. Said order is impugned in the writ application. Para. Counter affidavit has been filed on behalf of the state opposite parties, wherein the basic facts have not been disputed. However, the impugned order is sought to be justified by stating that in the meeting held on 19/2/2021, the lady supervisor, under the chairmanship of CDPO, the lady supervisor, health worker, and ward members were present, as also 23 women members of the concerned village. Accordingly, the matter was considered. Stop. Para. The petitioner has filed a rejoinder, specifically taking the stand that the meeting of the Mahila Sabha was ultimately abandoned. Meeting of the Mahila Sabha held on 19/2/2021 was ultimately abandoned as and no one was selected as Anganwadi helper. Heard Sri B.B. Mishra, learned counsel for the petitioner, and Sri A.R. Das, learned state counsel. Stop. Be it noted that despite valid service of notice, the opposite party number 5 chose not to appear. Stop. Reading of the impugned order reveals that the ADM, in course of hearing, found that a meeting of the Mahila Sabha was held on 19/2/2021 at 2 p.m. Stop. In the said meeting, the supervisor Mursundi and health worker were absent. Others including 23 women of the village were present. 3 candidates had applied. Stop. 2 were found to be not suitable or not eligible, while Basanti Amat ki je opposite party number 5, bracket opposite party number 5 was found to be suitable, having matriculation qualification. However, the meeting was abandoned and no one was selected. The ADM took the view that the applicant Basanti Amat, bracket OP number 5, is the only candidate to have passed matriculation examination, and the majority of women of the village present had supported her case. Accordingly, the ADM directed for her engagement. Sri Mishra submits that firstly, the no notice inviting applications was ever issued by the CDPO as provided in the guidelines. Secondly, the Mahila Sabha was abandoned as admitted by the CDPO before the ADM. Sri Das Leonard AGA also fairly submits on the basis of records that the Mahila Sabha held on 19/2/2021 remained inconclusive as regards selection of Anganwadi helper, and it had to be and it was abandoned for want of the necessary members. Stop. This court finds that as per clarification issued by, is this relating to Collector Baleswar district?
Both, collector both.
But can this be taken into account? This is for Baleswar only. Yes, Mr. Patnaik. Just now I came to know that I saw that this is only for Baleswar. Where is the Anganwadi worker only kotu achi amaro general response?
General 24/11/97 24/11/97 guideline for selection of helper for Anganwadi centers. 24/11/97.
Where is that?
Page 38. If that is the new book.
New book. Procedure.
Eligibility criteria.
Yes. This court finds that as per the guidelines issued by the government on 24/11/1997 for selection of helpers for Anganwadi center, there is no mention of any eligibility condition of being a matriculate. It is rather mentioned that preference shall be given to orphan, widow, separated, divorced or deserted women. Further, the selection is to be made by a committee consisting of under the chairmanship of the CDPO with the supervisor and ANM of the area being members. The committee is to select the helper in consultation with the women groups of the village. All right. Therefore, it is clearly provided that the selection is to be made by a duly constituted committee along with the members of the Mahila Sabha. In the case at hand, it is evident from the impugned order itself that in the meeting held on 19/2/2021, only the supervisor was present, but the health worker and ward member of the village were absent. This by itself makes the committee incompetent to select a candidate.
To make a selection.
To make selection. That apart, there is no requirement of any candidate having passed the matriculation examination. So, the ADM, despite noting the absence of the members of the committee as per the guidelines, held that the opposite party number 5 is suitable to be engaged only because she has matriculation qualification and her name was recommended by the women of the village. So, obviously, the ADM has no power to make a selection on his own in the absence of any recommendation by a duly constituted selection committee. So, as such, the impugned order cannot be sustained in the eye of law. Stop. Perhaps. For the foregoing reasons, therefore, the writ application is allowed. The impugned order under Annexure 5, the impugned order dated 2/12/2021, passed by the ADM, is hereby quashed. The selection committee, the CDPO, the collector both is directed to pass necessary orders for constitution of the
selection
committee for the purpose of making fresh selection of Anganwadi worker of the concerned Anganwadi helper of the concerned Anganwadi center strictly in accordance with the government guidelines referred above. Stop. The above exercise shall be completed within a period of 2 months from the date of production of certified copy of this order by the petitioner.
As on the date of selection, the rules prescribed for selection of helper.
Let them find out. I'm going to as per the prescribed, as per the
prevailing
guidelines for last line the company. In accordance with the I said the government guidelines referred above. So I have mentioned which guideline I have. So they will consider it. All right. Remaining matters after recess. You are still looking sad, Mr. Mishra. I remember you always smiling. Now you are looking very sad and very serious.
I have become old.
Say anything.
On 10/9/2019, advertisement was published for the purpose of appointment of Anganwadi worker. Accordingly, two candidates were selected. That means there are page 10, annexure 2. Two candidates were selected. The present petitioner is number 1 and another is one Priyanka Paikrai. Thereafter, your lordship, objection was called for, but no objection was received by the authority. Kindly have a glance to page, your lordship, 21. 21, and that is the guideline. 6th line. Ready? The committee will notify the candidate selected on the same day in Panchayat Samiti and CDPO's office and within 48 hours at the GP and village level. CDPO is authorized to issue engagement order in favor of the candidate selected, and this should be issued within 24 hours of the selection of the candidate. They didn't give, allow us to join in the reason what they are saying in counter. The reason they have stated that one Lipi Behera, she is not aware about the advertisement. Thereafter, that is counter page 12, your lordship. When I got the document, it was clearly written in there, your lordship. Anukullere Prathamika Vidyalaya Anukullere hebako diyo kendra pai.
Where are you reading from?
Counter of page 12. The reason for not giving me not allowing me to join in the join as Anganwadi worker is they have filed at
Where have they stated in the counter affidavit? Where is the pleading?
Yes. Para 5. No, sorry.
Para 6.
Sorry. Para 6. Sorry.
Yes.
That is there as ଯୋଉଥିରେ କି ସେ କହୁଛନ୍ତି ଶିକ୍ଷକ ଦରକାର ଥିବା ଜାଣି
କଣ ଲିଖିଛନ୍ତି? Let us see first.
ବଡାସ କଣା ଜିଲ୍ଲା ଲିଖିତ ଆକାରରେ ଜଣ.
Please come to paragraph the counter affidavit.
Yes, your lordship. In reply to averment of made in paragraph 4 of the read petition, it is humbly submitted that in pursuance to the advertisement dated number so and so dated so and so and two persons, including the petitioner, has applied for appointment of Anganwadi worker. The verification made, that is para 6, para 7. Para 7 is the letter of Lipi Behera. That in reply to averments made in paragraph 5 of the read petition, it is humbly submitted that after verification of documents, the CDP of Konas, by this office letter number 584 dated so and so, invited objections from the villagers of the area concerned. Copy of the letter is annexed 3/C. As per the above letter, a number of villagers of Toropada 2 and also Lipi Behera have made an objection that they were not aware about the said advertisement. But your lordship, kindly have a glance to page 8 of my read petition.
Just so what is the document you are referring to? Para 12. Page 12.
Page 12 of the counter.
Yes, what does she say?
4th line.
निवेदन अभिप्राय कि आम लिपि बेहरा गला प्रथम अनुकूल अंगनवाड़ी केन्द्र शिक्षक दरकार थिबा जानी आम उपयुक्त मन कर दरखास्त
से शिक्षक कहते किंतु एडवर्टाइजमेंट होची अंगनवाड़ी वर्कर पई.
Yes. How to justify? There was an advertisement.
Whatever has happened has been stated in the counter.
No. There was an advertisement.
Yes.
So in that advertisement, pursuant to that advertisement, only there were 2 applicants, including the petitioner. That also you have admitted in the counter. Now they were selected. One of them was selected. Who was selected?
Present petitioner.
Was selected. Now that Lipi Behera files this document,
yes,
which you have enclosed, which is in fact, firstly, it is not for Anganwadi worker. And secondly, at the stage of objection, she cannot say that I was not aware of the advertisement. So it means the timeline kora hai na.
Yes.
And on last occasion, this honorable court has directed me to take instruction whether any Anganwadi worker has been appointed in Toropada to center or not. So on verification, my instruction is that one Lolita Behera, who is the Anganwadi worker for Toropada 1,
has been given in charge.
ସେଇଟାର ତରପଡ଼ା 2 ର ବି ନେଇଛନ୍ତି ପ୍ଲସ୍ ବାଲିପାଟଣା 2 ର ବି
Charge
charge ରେ।
naturally, the function, the center cannot remain idle. It has to function.
For that reason, I have filed this writ petition.
So,
To the
what to do? This cannot be sustained. This cannot be sustained. It appears
not have been in the manner they have.
This is what you have said in your counter.
Yes.
Paragraph 7. And alleging about insufficient notice invite. So if there was, how can there be insufficient notice if there is an advertisement? Unless there is a specific case of some party that advertisement was never really published. It was
as prescribed, it was not published.
Yes, it has to be published in a newspaper, isn't it? You have in paragraph 9, you say that all the procedure as per government guidelines have been followed.
Yes.
Only because somebody raises an objection subsequently, the selection process cannot be stopped. I am allowing the writ application. The petitioner has approached this court with the following prayer. The case of the petitioner, briefly stated, is that an advertisement was issued on 10/9/2019 by the CDPO Konas in the district of Puri for inviting applications for engagement of Anganwadi workers of Ko Jagata? Toropada 2 Anganwadi Center under Konas Gram Panchayat.
under Bodaso Gram.
Konas na eta kole khaji Bottaso.
Bodaso.
Nahi Bottaso. ওড়িয়াটা পড়ুছি বত্তাশ লেখাইছি দেখিলে come to page 7.
Page 7 রে
বত্তাশ
আগে
বত্তাশ গ্রাম পঞ্চায়েত and another Anganwadi center. The petitioner submitted her application for engagement under engagement in Konata Toropada 2 Anganwadi center. There was another applicant, namely Priyanka Paikrai. So, their applications were considered along with considered and their documents were verified by the CDPO, by the committee headed by the CDPO. And thereafter placed before the selection committee. At this stage, the selection committee with the petitioner being placed at serial number 1. At this stage, objection was invited by notice dated 26/9/2019 on such selection. Stop. At this stage, thereafter, no further action was taken, for which the petitioner approached this court in the present writ application. Counter affidavit has been filed by opposite party numbers 2 and 3. State opposite party, bracket opposite party number 2 and 3. Inter alia, admitting all the relevant facts. It is, however, stated that pursuant to notice inviting objection, a letter of number of villagers of Toropada 2 and of one Lipi Behera was received to the effect that they were not aware of the said advertisement. It is also stated that all the procedure as per the government guidelines for appointment of Anganwadi worker had been followed. But due to such objections raised by the villagers, the appointment could not be finalized. The petitioner has filed a rejoinder stating that the advertisement in question was affixed in the Gram Panchayat office, being duly signed by the Sarpanch and ward member. Therefore, it cannot be said that no one was aware, that the public was not aware of the advertisement. Stop. Heard Sri Ellen Rohit Singh Para? Ellen Rohit Singh, learned counsel for the petitioner, and Sri R. Das, learned AGA for the state. Para. Sri Rohit Singh would submit that there being only 2 applications received, including that of the petitioner, pursuant to the advertisement, and there being also a process of selection in which the petitioner was found to be more suitable than the other candidate, there was no reason for the authorities to stop the selection process midway. He further submits that the so-called objection raised by the villagers and Lipi Behra are untenable. So, moreover, said Lipi Behra had submitted her objection, indicating that she was interested for the post of teacher and not Anganwadi worker. Para. Sri Das, learned state counsel, submits that all necessary or all the procedure laid down in the guidelines for selection of Anganwadi worker issued by the government on 2/5/2007 have been scrupulously followed. Since an allegation was made that the advertisement, that the general public were not aware of the advertisement, the selection process could not be taken further. Para. This court finds that the basic facts of the case are not disputed. In fact, the state authorities have admitted the following facts, admitted the relevant facts in the counter affidavit as follows. Para 6 or 7 court kholge.
In para 10, they have said that the instruction was sought for from the sub-collector Puri.
I'm coming to it. So sub-collector will be given a direction that to complete the process. It is further seen that
paragraph 10,
in view of the objection raised by the villagers, the matter has been referred to the sub-collector Puri, who directed the CDPO to conduct inquiry. However, the final order is yet to be passed by the sub-collector. In the inquiry report submitted by the CDPO, a copy of which is enclosed as Annexure F/3, it is simply stated that in course of the inquiry, several villagers claimed that they had no knowledge of the advertisement.
That is, এই যে objection হয়েছে 2023 মସିহাରେ advertisement হচ্ছে 19 ର.
And their signatures have been obtained. Stop. Where is that guideline? Yes. the stand taken by the state appears to be contradictory, inasmuch as at one place it is categorically stated that all the procedure laid down in the guidelines were followed. And at another place, it is reference has been made to the allegations submitted by the villagers. Stop. As per the guidelines, the unless there is a specific stand taken by, unless it is the specific case of any person that the advertisement was never actually published, no inference can be drawn simply on an objection that it was not within the knowledge of the general public. Moreover, this court finds that the state also accepts that there were two applicants, including the petitioner, pursuant to the advertisement. It is nobody's case that there was any foul play involved to somehow restrict the advertisement to only two persons rather than the general public. Stop. The report of the CDPO is also not conclusive, inasmuch as the advertisement was issued in 2019, whereas the inquiry was conducted much later, that is in the year 2023. That apart, the sub-collector has not passed any final order as yet. So we'll direct the sub-collector?
Yes.
Unless, I'll give him a leverage, unless he finds that there is any actual foul play, that the advertisement was
Not
publicized.
Because his opinion was sought for and it was.
He has not given any opinion.
Yes, had not given till
In any case,
2023.
this court finds that the matter is pending with the sub-collector. Sub-collector ko jaga?
Konas.
Sub-collector
Sorry.
Konas.
Puri.
Sub-collector Puri. Such being the factual position, the writ application is disposed of, directing the sub-collector Puri to take a final decision in the matter as early as possible, preferably within 4 weeks from today. Stop. It is needless to mention that unless any concrete evidence of foul play with regard to publication of the advertisement is found, the process of selection already initiated shall be taken to its logical conclusion without any further delay. That's all? Yes.
Item 21. সেটি যা বতাস লেখা পেজ 710 রে মোর আছে বড়াস সেটা
Boraso.
বড়াস বতাস
Oh, Boraso করলু।
আগলে
Item 21.
Yes. And matter relating to selection of Shiksha. As your lordship knows that the Babita Sapati's case. And the petitioner was one of the applicant in that case. And the ground of rejection, rejecting the candidature of the petitioner,
Overage.
Overage candidate एमे
Hmm.
माने 35 जन थिले out of 35 34 have been given engagement after dismissal of the SLP review petition has been referred by the state that has been contained in content petition also. The ground of rejection in lordship may turn to page 49 annex 10.
Has counter affidavit been filed? The counter is not necessary.
No counter affidavit.
Lordship में
Yes.
Only
next
instructions have
page.
been received.
Next page. Page 50. That while examining the writ appeals, one application form bearing application number such and such of Vidyadhar Naik applied for the post of
You are Vidyadhar Naik.
again, which is not applicable for the post of Shiksha Sahayak as per the advertisement dated 12/9/14 and School and Mass Education Department. That while such fault came to his knowledge, then he submitted an application on 25/10/21 to the undersigned with an affidavit to the effect that and requested to consider his application for the post of Shiksha Sahayak junior teacher contractual instead of application form of contract teacher. That although the petitioner has submitted an affidavit made before the Notary Public Cuttack stating that the online application form which has been submitted earlier neither intentional nor deliberate, rather due to clerical mistake. But the petitioner had neither took any steps nor submitted, filed any application, in this case, before the Honorable Court, concerned authority, to consider his application for the post of Shiksha Sahayak instead of contract teacher. Besides, is a bold letter. Besides, the undersigned has no jurisdiction to change the cause title of the writ appeals, in which it is mentioned that the matter is related to engagement of SS. Further, filing of affidavit before the Notary Public cannot override the judicial order passed by the Honorable High Court. Thereafter, the legal opinion of standing counsel S and ME said Cuttack was obtained. The standing counsel by letter dated 30th.
We'll call for that record.
Has offered his views that those who have applied for the post of Shiksha Sahayak only and those applications are available in record, those cases should be considered, and those who have applied for some other post and those applications are not available.
All right. Which is that record? Which is that case which you had filed earlier?
Writ petition.
You have filed a writ application?
Yes, one of the applicant in Bhavita Satati's case.
That is why let us call for that record. Call for Seithira Apanga Nata Thibo?
Again.
We'll produce the averments. Then we can know what you had applied for.
No,
Yes.
What I beg to submit before your lordship, that while filling up the online application form, the opposite party number 2 is the competent authority.
So
before I have submitted the online application form, that online application form is very much available with them.
What had you mentioned there? Contract teacher.
But in the appeal, they have not considered all these documents which has been filed before them. Taking into account the appeal memo, they have proceeded.
What had you mentioned? You filed an affidavit.
My lord.
You had applied for Shiksha Sahayak or for that post, junior teacher, contractual or whatever? ଆପଣ contract teacher ବୋଲି ଲେଖିଥିଲେ ବୋଲି ସେ କହୁଛନ୍ତି।
ଦିଟା advertisement ବାହାରିଥିଲା। 35 ଜଣଙ୍କର ଯେତେବେଳେ appeal file ହେଇଥିଲା writ petition, ସେତେବେଳେ by mistake ଜଣଙ୍କର document ଥିଲା ଏଇ ଯୋଉ ବିଦ୍ୟାଧର ନାୟକର ଥିଲା contract teacher admitted। କିନ୍ତୁ writ appeal ରେ ଗଲା, writ appeal ରେ direction ହେଲା ଯେ ସବୁ appellant କୁ consider କରିବା ପାଇଁ। ସେଥିରେ state ଯାଇଥିଲା SLP ରେ, SLP has been dismissed। तापरे contempt है, contempt रे भी देखो तो तार cost title रे तार ना आज page 40 lordship matter।
So Mr. Das, you will have to take instruction.
The instruction of October 2023 is as the cause title of the writ appeals bearing WA number such and such was relating to the matter of Shiksha Sahayak and the petitioner had annexed his contract teacher application form in the said writ appeal. SPD OACPA had rejected the case of the petitioner by OACPA order number such and such dated 1/11/2021. The copy of the said order is enclosed herewith. That order has been enclosed 1/11/2021 that he had not applied for Shiksha Sahayak, but for contract teacher.
Yes.
That is what the...
What is your stand? He says that he was one of the applicants in that Babita Satpathy case.
Yes.
So whatever was passed order was obviously in respect of all the petitioners, isn't it?
And now the state project director, which is impugned as annexer 10.
Yes.
There it has been so held that legal opinion of the.
No, I don't think this is probably a technical plea they are taking. Hypothetical plea.
That those who had applied for the post of Shiksha Sahayak, only those applications.
So what was your application?
I have annexed under annexer 2 to the present petition.
Online application. Application for the post of Shiksha Sahayak ऊपर लिखा है इसे?
ये कौन हिंदी बोल?
Yes. This is a copy of that application.
Annexer 2.
ତାଙ୍କ ଅନଲାଇନ ରେ ସେଟା ରହିଛି ଶୋ ବି କରୁଛି ଅନଲାଇନ ଗୋଟେ ନମ୍ବର ଜେନେରେଟ ହେଇଛି ଦେଖନ୍ତୁ ଆପ୍ଲିକେସନ ଫର୍ମ ନମ୍ବର ଓଟିଇଟି ନମ୍ବର ଓପି ନମ୍ବର 2 ଙ୍କର ଅଫିସ ର ସେଟା and your lordship may remember that Babita Satpathi's case that matter which has been argued by my lord and senior Mr. Rautray. They have prepared a list of overage candidate. In that said list also his name found, and the contempt order as well as the review order that is under annexer 5-8 page 40 lordship, turn to page 40.
Yes.
The petition name found place at serial number 3, Vidyadhar Naik. Then operative person, order dated 18/11/22. Now that the review petition, review 72 of 22 has been dismissed today, this contempt petition is disposed of with a direction that there should be a full compliance of the order in question by the state within a period of 2 months.
All right. You take instruction with regard to annexure 2.
Yes. Since he had applied for
yes, in course of hearing, learned counsel for the petitioner submits.
Or may I submit, your lordship may direct the
order টা হইছি 18/11/22.
Whatever, rightly or wrongly, he has passed an order.
Mind.
Holding that, you had not applied for Shiksha Sahayak. Now you are coming up forward with a document, which is annexure 2, showing that your application was for Shiksha Sahayak. So this document does not appear to have been considered. Let him then consider. We'll dispose it off. The petitioner challenges order dated 1/11/2021, passed by the state project director, OSEPA, wherein the petitioner's claim for appointment, claim for engagement as Shiksha Sahayak / junior teacher contractual, being an overaged candidate, was rejected. Stop. Perusal of the impugned order reveals that the petitioner's claim was rejected on the ground that he had applied for the post of contract teacher, but not for Shiksha Sahayak, as per advertisement dated 12/9/2014. Stop. Learned counsel for the petitioner, however, draws attention of the court to copy of the online application submitted by the petitioner, enclosed as annexure 2, which clearly shows the same to have been submitted for the post of Shiksha Sahayak. Such being the case, let the state project director reconsider the claim of the petitioner after referring to the online application form of the petition and take a decision thereon within 4 weeks from today. Stop. The impugned order dated 1/11/2021 is hereby quashed and the writ application is disposed of in terms of the observations made above. That's
okay.
Item number 22.
Item number 22, my lord. And I am filing the rejoinder today.
Have you served copy?
No, just now.
Take it up on some other day. Then counsel for the petitioner files rejoinder in the court after serving copy on the state counsel, who requests for some time to respond. List this matter. 22nd August. 2024 matter.
Item 43.
43, my lord. Last occasion 8/5/2024. Time was granted to file counter affidavit, not yet filed.
Yes, you said that it is ready and it will be finalized.
Yes, final, it could not be finalized because he had not come to make it finalized.
State counsel requests for some more time to file counter. List this matter on
8th August.
8th August. Counter will be filed in the meantime positively.
There is an entry.
Entry order to continue.
Item 45.
May I please? I'm for the opposite party.
Madam, I am the petitioner. Madam, I filed the transport petition. Transport the case Sambalpur, madam, because marriage was solemnized at Sambalpur and it was consummated at Sambalpur, madam. Nowhere it was performed at Bhubaneswar, nor the opposite party with the petitioner in the CP petition, madam. He belongs to Sambalpur. I have got the online porta of his father that he is Golok Bihari Nath with Mohan Charan Nath, that the Brahmana Buddha Raja Sambalpur. This is the Pota Malad is a permanent house here, and his father was reading in schooling at here. He completed his GM college study in Gangadhar Medical College. He was serving as a non-gazetted lecturer of SSB in Sambalpur district and in the periphery of Sambalpur, madam. No, and he retired as a lecturer at Sambalpur. His mother was serving as a school teacher in English Galtakur Sambalpur, retired as a under Sambalpur district. In the meantime, in perhaps 1916 or 116 or 17, they constructed a building at Bhubaneswar, and they obtained some other certificate that permanent resident. It is a fake
Yes. What do you say? Who's applying for the other side?
This is the online quota matter.
Yes, what do you say?
Trying to agenda material.
Why?
Lord, Indra Sudden is suffering from illness, so he is unable to appear before this lordship. So
let there be a stay, madam. Let there be a stay. They are continuing parallel proceeding there, madam. They are appearing in cabinet. They are opposing my.
All right. Prayer for adjournment is made on behalf. Prayer for adjournment is made on behalf of the opposite party on the ground that the council is ill. List this matter. I told you go. On 8th August. In the meantime. I am a ଟିକେ ଆପଣ ଯଦି ଟିକେ ମତେ ଛାଡନ୍ତେ ମୁଁ ଟିକେ ଅର୍ଡରଟା ଡାକନ୍ତି. Further proceedings in CP case number 348 of 2023 pending in the court of learned judge family court. Family court 1 or 2?
Bhubaneswar 1.
Bhubaneswar
1.
Family court 1 Bhubaneswar shall remain stayed till the next date.
26.
May I please, Lordship?
Yes.
In this matter, Lordship, last occasion, Lordship directed the state regarding the serving of the notice for the opposite party, Lordship.
Anybody appearing?
Yes, Lordship.
Yes, anybody appearing for the opposite party?
Not yet.
Well, it will take it up for final disposal on some day. You appear physically. Please this matter. Now, the learned counsel of the petitioner is present. None appears for the opposite party despite repeated calls. List this matter
16th August.
on 16th August. Yes.
Item 27.
Humbly pray, Lordship, the interim arrangement may kindly be extended.
Oh, see you adjournment karo. Yes.
Item 27.
Item 27.
I'm from the petitioner. Find this transportation from more court benefit to Nabarang.
Yes, what is this case? You are the wife.
No, I am the wife.
You are the wife. Acha. So,
Lordship, as per direction of this honorable court, before I will appear surrender and religion bail. On the same day, ସେ ଯେତେବେଳେ ବେଲ୍ ରିଟର୍ନ କରୁଛନ୍ତି ସେତେବେଳେ ତାଙ୍କର ୱାଇଫ୍ ଆଉ ତାଙ୍କର ଅଦର ଫ୍ୟାମିଲି ମେମ୍ବର ମିଶିକିନା ତାଙ୍କୁ ଆଟାକ୍ କଲେ ଯାହାଫଳରେ ତାଙ୍କୁ ପୋଲିସ
charge sheet has been submitted also.
Yes.
323 is one of the 323 is one of the 323 506 is there.
Yes.
On the same day, my lord, 2 FIR has been lost, my lord. That he has suppressed, my lord. The petitioner and along with friend, my lord, they have created disturbance with the opposite party too. This is the FIR, my lord. And this FIR has been lost only to transfer the case, my lord. And it's a criminal trial, my lord.
No, this FIR was lodged in June 2023. You have lost this FIR in January 2024.
No, man. Again, they have lost, my lord. Another FIR. This is the subsequent FIR, my lord. On the same day, my lord, 2 FIR has been lost, my lord.
No.
They have created disturbance.
You come forward with that.
My lord.
You say that there was another FIR lodged.
My lord.
He has lodged an FIR, which is Navrangpur PS case number 151.
My lord.
Dated 22/6/2023, which has culminated in the charge sheet. Isn't it?
No. That is not.
Navrangpur PS case now 54, dated 21/24, in which charge sheet has been filed under section 341, 294, 323, 506 against one Munni Panka, Pushpa Panka, Kausalya Panka, or Sonia Panka. Is 4%.
Yes.
No, my lord. First FIR is, my lord, the petitioner lost, the present opposite party lost the FIR, my lord. That is 498, 323, 307, my lord. In that case, bail was granted, my lord. After being released on bail, they created the disturbance for which, my lord, there was 2 FIR on the same date, my lord. This is the present FIR which I produced before your lordship, and another the charge sheet was submitted in that case.
No, this GR case number 265/2023 relates to which case? Sir, Umar Court was there.
Yes, my lord.
That is in Umar Court.
Yes, my lord. For that reason, they want to transfer the case, my lord.
Umar Court PS case number 54.
No, this is confusing because the FIR which is annexed as Annexure 1, I wanted to see the charge sheet in that
Yes,
case.
I have filed, my lord. I have filed by way of memo, my lord.
That is, sir, FIR number 54.
FIR number 54.
But Annexure 1 is FIR number 151. You have submitted charge sheet in another case.
Yes, in the case when the accused persons were released on bail, returning to home, the petitioners in that case,
He has sought for transfer on the ground that he was threatened, beaten up, etc., etc. And to that effect, he has lodged an FIR, which is Annexure 1.
No,
Which is Annexure?
That is Annexure 1 is previous FIR, my lord.
previous.
Annexure,
That is Umar Court
Annexure 2.
case number 54.
Yes, lodged.
In that case, charge sheet has been filed.
Charge sheet has been filed.
Yes.
Yes. And what about this FIR?
My lord.
What about this FIR?
Investigation is going on, my lord.
Who has lodged it?
Yeah, the present opposite party too, against the petitioner and his friends, my lord. What are they? You just as
Ask the, now you obtain instruction in this regard. It is not clear at all.
Copy of the FIR may.
Yes,
Aji just received call, but it goes.
In course of hearing, Shri Tukuna Kumar Mishra, Parent Counsel appearing for the opposite party wife, produces copy of an FIR in Umar Court PS case, Navrangpur PS case number 54.
No, my lord.
Umar Court PS case number 54. Dated?
And opposite party has lost Umar Court PS
Dated
case number
21/2024. Stop. Learned State Counsel shall obtain instructions with regard to all the cases pending between the parties.
Yes.
Place this matter on 1st August.
Item 29.
Oh, yes.
28 कौन सी? Oh, let's say Mr. Patnaik, Sushil Patnaik was appearing for the other side. He fell ill. So he immediately, I have adjourned it.
Yes.
AC ଟା ଚଲେଇବା ପାଇଁ କହୁନ
29 matter regarding transfer of RCC case from JMFC Nimapoda to JMFC Bhubaneswar, my lords.
What about the notice?
It is served, my lords. Mr. Shakti Prasad is appearing on behalf of the opposite party, my lords.
Mr. Das probably was making a mention in the morning. Mr. Shakti Prasad Das. Probably he was making a mention. All right, we'll adjourn it. Is this matter?
1st August.
On 1st August. Yes.
30 तारीख दिन hearing होता है गुरु गुरु डेट जुलाई 30
Adjournment. Adjournment कर दूँ. Yeah.
Item note 30.
Please, your lordship. Lordship, today we have filed a wakalatnama on the behalf of the husband, lord. 2 weeks time may be granted to file the objection.
Item 30.
ये अपन ଥିଲେ तो adjourn कर ले. It has been adjourned. You are not there. कोडी. आपण शक्ति प्रसाद दास टी. ମୁଁ ଆଜି ଆପଣଙ୍କୁ ଚିହ୍ନିନି 30 ବର୍ଷ ହେଲାଣି ଚିହ୍ନିଛି ମୁଁ ତ ଏତେ ଜୋର ବଡ ପତ୍ରିକା ଦେଖିଲି ଆପଣ ଶୁଣିଲେନି ଆପଣ ଟିକେ ନିଦ୍ରା ହେଇଯାଇଥିଲା ନାଇଁ କଣ କରିବା ନିଶ୍ଚିତ କଣ ହେଲା କୋଉ ଯାଇଛି 1st ଅଗଷ୍ଟ କୁ ଯାଇଛି what is this କଣ ସେଟା କଣଟେ
Wakalatnama on the behalf of the opposite party husband, lord.
G.K. Mahathi, advocate and associates have entered appearance for the opposite party. Therefore, adjournment is made. Sir, you have any instructions regarding mediation?
No, your lord.
All right. What about you? You are the wife?
Yes, ma'am.
What are you agreeable for mediation?
Take instruction.
Yes?
I will take instruction.
All right. As requested by learned counsel for the opposite party, list this matter. Huh?
8th August.
On 8th August. The parties, the learned counsel for the parties are requested to take instructions from their respective clients if they would be agreeable to mediation for settlement of their disputes. Yes.
Item 31.
Made me so. On the last occasion, your lordship directed me to supply copies to the state council for.
Now the other side has already appeared.
You are appearing?
Yes. And 2 weeks time we granted to file the objection.
Objection? Oh, objection for? Okay. Therefore, adjournment is made on behalf of the opposite party. List this matter August or date
16th August.
on 16th August.
Interim order to continue.
Is there any stay or
Yes, madam. There is a stay.
interim order to continue?
Grateful.
Item 32.
Your lordship, on 27/6/24, would give direction that.
All right. Requisites file be accepted and notice be issued, fixing a short returnable date. Is this matter
9th August.
on 29th August? Yes.
Item 33.
33 and for the petitioner wife may not challenging for seeking for a transfer of the matrimonial suit from.
Was notice issued?
Malay?
Was notice issued?
Yes, your lordship. On the
Let us
last.
see. Office note indicates that, yeah, pay attention. See, BPB Bahali, advocate and associates have entered appearance for the opposite party. Learned counsel for the petitioner is present. List this matter on 16th August, indicating the name of Sri Bahali and associates in the cause list.
the interim order for
Adjournment.
Item 34, may I, last occasion, the notice was issued.
But instead of filing, requisites for speed post, you have filed for it. Let's say previous cases, you order set according. Notice requisites filed be accepted and 29th August.
Item 35,
May I please?
Yes.
Largest lordship has issued notice my friend is appearing. For counter mate debe boli kohuchi.
Any chance of settlement?
Conciliation failed valid.
Failed. It is never sent to conciliation.
Seti.
All yes.
The wife is the petitioner and she seeks for a direction for transfer of the CP case from Cuttack to the file of Law and Civil Justice Senior Division, Karanjia. The 125 proceeding is also there in Karanjia and husband has appeared. That case is at the stage of adducing evidence.
From the Court of Learned Judge, Family Court, Cuttack, to the Court of Learned Civil Judge, Senior Division, Karanjia. Wherefore, transfer has been made on two grounds. Firstly, that the petitioner is residing at Karanjia. And secondly, another proceeding between the parties is pending at Karanjia, in which the opposite party husband has already entered appearance.
And another is there is a 3-year-old girl child is also.
Further, the petitioner has a 3-year-old girl child. As such, it would be inconvenient on her part to travel to Bhubaneswar, to Cuttack, to attend the court on the dates fixed. Sri Gopinath Mishra, Learned Counsel appealing for the opposite party, has opposed the prayer for transfer by submitting that the petitioner had herself stated her address, showing her a resident of Cuttack, and has subsequently taken a different plea. After considering the submissions, this court submissions and the relative inconvenience that may be caused to the parties if the proceeding is allowed to continue at Cuttack, this court finds that this court is of the view that more inconvenience would be caused to the wife thereby. Under such circumstances, the prayer for transfer is allowed. It is directed at so and so. Tapre, virtual board and personal attendance will not be insisted upon unless it is absolutely necessary. Yeah, order number.
ଟିକେ ଟାର୍ଗେଟ ହେଇଗଲା କାହିଁକି ନା ଏଇଟା ଏସଡିଜିଏମ ଙ୍କ ପାଖରେ ଚାଲିବ 125 ଟା ଏଇଟା ସିଭିଲ ଜଜ ଙ୍କ ପାଖରେ ଚାଲିବ ଗୋଟେ ଡେଟ୍ କୁ ବି ରହିବ ବୋଲି କିଛି ମାନେ
Further, the court below shall do well to try and dispose of the case as early as possible, preferably within a period of 4 months.
36.
Big part.
It's not the white man.
Item 36.
Hon'Ble to Rourkela.
You are from? You are for?
Ajay.
Yes, Mr. Sahu, you are for?
Big pardon, Your Lordship. I am for the husband, my lord. Mr. R.K. Mahapatra appeared in this matter, Your Lordship. He is on the lakes, my lord, before another coordinate bench.
Well, let it come next week.
My lord, great.
Next week, as well. Let's this matter next week.
Date fix.
Yes?
Date not as you only next week.
Next week, but next year, I say date photo. Date.
Item 37.
File that requisite instead of
Requisites filed be accepted and notice be issued as directed by fixing a short returnable date List this matter?
29th August.
Huh?
29th.
On 29th August.
Item 38.
May I please, Your Lordship? Filing the transport petition, they transport the CP case from Lanejja's Family Court Baleshwar to Lanejja's Family Court Bhubaneswar.
Yes.
Your Lordships, we have instructions to appear for the opposite party, Your Lordship. We'll be filing the wakalat number in course of the day, Your Lordship.
All right. Miss Bini Mishra appears and submits that she has instructions to appear for the opposite party and undertakes to file wakalatnama within
In course of the day. Your
in course of the day. List this matter
16th August.
on 16th August.
Right. Item 39.
May I please, Lordship?
I have both the appellant. My warrant friend, I wakalatnama without my consent.
Strength of my lord, prisoner petition.
Where is the prisoner's
The
petition?
appellant.
Was any judicial order passed?
Yes, my lord. Earlier order is there.
On the strength of
For the second appeal also, there is prisoner petition and wakalatnama.
I don't like this. You engage a lawyer and then you get it changed. In one case, I had directed an inquiry to be conducted.
Yes, my lord, in one of the cases.
Yes. You This part of the thing is very unpalatable. You don't want to engage a particular lawyer, it is free, you are free to take his consent and engage somebody else. But making an allegation. All right, okay. Yes.
My name.
Will be deleted.
For the appellant number 1, my lord, Bank of Era 452, CRLA 452 of 2022, my lord. I am filing one IA for bail, my lord. He is the father of the prime accused, my lord. He is charge sheeted under section 302-201 34 of IPC, my lord, but convicted under section 304 part 2, my lord, for the period of 8 years, my lord.
Why has it come to me? Did I dispose of any?
He was once not pressed. I think so. That's right.
But there's no endorsement of the Chief Justice. How can I take up this matter? Let us see. Probably I had admitted the appeal.
One IA is disposed of by this honorable court.
No, that is all right. But there has to be a endorsement by the Chief Justice. I cannot assume jurisdiction on my own. Get my point? You are right. I've seen that order.
Admitted by, I think so, Honorable Justice Sangam Kumar sir.
No. So.
1822, Your Lordship.
1822.
1822. And that IA was disposed of by Your Lordship on 5/12/22. Not pressed. That was
Not
IA.
pressed.
Yeah, that's true.
Thereafter,
There has to be an endorsement by the Chief Justice. It may come to me, but again, unless the Chief Justice endorses, it is not within my assignment. Since this case is not in my assignment, in the assignment of this court, registry to do the needful. Then registry will understand what to do. Are same.
I don't know, 40.
Allowed to dispose of the application and granted 4 months interim bail. Now, the case has been committed to Court of Sessions at that time, my lord. That has not been, yes.
Court below no kori, court in session over the matter kar dele hijo.
Seti koli.
What do you say?
Yes.
Instead of the word below occurring in the third line of paragraph 6, the words in session over the matter be added.
Copy.
answer throughout of talent modify.
In course of the day, yes.
Okay.
Item 41.
That case, my lord. Where my lord was pleased to grant him bail, considering the fact that though he is in custody since last 2 years, that A and B has not been examined. And my lord, on the last occasion, my lord received the order dated 20th June 2024.
Yes.
While considering that application, my lord was pleased to consider the fact that the case was posted to 22/6/2024 for hearing of the case. And on 22/6, whether that witness was not produced, not examined. On 22/6, again the case was adjourned to 4/7/2024. PO was absent and case has been adjourned again.
So when is your bail, when is your interim bail expiring?
Expiring, well, on 20, it was granted for 4 weeks.
No, release will happen, na?
From the date of release.
From the date of release.
21 days. Pilot was pleased to release him on 20th. 6.
No, but when were you actually released?
On 21, well, it is completed on 21.
No, that order, but you must not have been released on 20th. You must have been
Well,
released
2 days after.
2 days after. So by
Well,
Tarigo.
accordingly, to 21 is the date. 21 Sunday.
21 is also.
22nd.
Yes. What do you say? What do you want now? You want extension?
Further 1 month may be extended. Next.
1 month of 1 month of 2 weeks of it.
Yes, madam.
Very
Next
sensitive
date,
case.
Probably next date.
Next date is 18. Exam
Aji.
Today.
It was posted today. Because
But I am granting you 2 weeks time. In the meantime, you inform.
same ballot with only thing, same bail bond में करते.
अब bail bond कौन? अपन तो release है ना. Detail continue करेगा तो अपन you don't have to submit any bail bond. You are already on bail. You don't have to.
Already on bail. It will be extended.
Sri DP Dhawal and Senior Counsel submits that a trial has not yet been concluded, and the witnesses named Mr. A and Mr. B have not been examined as yet. He therefore prays that the interim bail granted by this court by the order dated 26/2024 be further extended. Learned State Counsel submits that the witnesses named Mr. A and Mr. B have not been examined on the date fixed, as the presiding officer was on leave. Stop. This court, by order dated 26/2024, taking note of the inordinate delay in examination of the aforementioned witnesses, above named witnesses, deemed it proper to grant interim bail to the petitioner in view of the fact that he was in custody for more than 2 years.
Today, when the case was posted, witness has not been examined. That is the instruction. Certified copy I have not.
Considering the above, the interim bail granted by the order dated 26/2024 is further extended by a period of 3 weeks.
3 weeks, man.
With all other, then extended.
Conditions are there, but that same conditions may be.
On the same terms and conditions.
Conditions were there.
As imposed.
Item 42. I have filed this IA for extension of time. In the meantime, he has already been surrendered. This IA may be infructuous.
IA is dismissed as infructuous.
Item number 43.
Last case under section 20B2C, he is in custody since 2 years 11 months. My lord, custody since होची 23/8/2021 ताପରେ दीटा बेल फाइल हेइथिला गोटे होची 4941 of 2022 जोटा कि dismissed for default for non prosecution हेइथिला सेटा CRL में पुनी फाइल करथिल पूर्व वकील सर जोडी सेटा को से विड्रॉ कर देथिले तापर मु गोटे CRL में एबे गोटे फाइल करछि विथ लिमिटेशंस तो दीटा सेट में टैग अछि सेटा को जदी हजू रिवाइव करी कि मु सेटा को विड्रॉ कर देबी ताले नो एप्लीकेशन जोटा हजूंगा पाकर अछि 3863 सेटा हजूर हियर
No, this CRLMA relates to which bail application?
4941
Which was dismissed for default.
dismissed for default है सी गोटे CRLMA फाइल कले से CRLMA से पुनी विड्रॉ कर देले तापरे केस न्यू करी के मो कति आसला तो सेते पुराना केस रे गोटे CRLMA along with limitation petition फाइल करछि
Just see. So this CRLMA application relates to BLAPL number 4941.
आज्ञा अब हजूर को पाखरे पूर्व
So this you have not filed this.
ना ना सी अलगा जने सार करथिले
ठीक अछि.
आज्ञा
So
सेटा रिवाइव हे गेले एटा
so that application will be revived.
आज्ञा रिवाइव के मो विड्रॉ कर देबी 3863 जोटा हजूर को पाखरे अछि सेटा हियरिंग कले
कोट एटा करिके आपण विड्रॉ करियो.
आज्ञा आज्ञा
Yes, what do you say?
4941 रे सेटा तो पेंडिंग अछि CRL मेटा
No,
No, he's saying that if this restoration is allowed and that matter is restored, it will be restored again. He'll withdraw it.
Yeah.
He'll withdraw it so that the second application can be made.
Maybe hard.
All right. CRLMA. Stamp report together.
है 24 of 2024.
All right. Considering informations, the bail application is restored to file. Well, where is that other bail application?
3863
That other one. Today अपना video करे 4941.
4941 टा
हाँ. सेटा आसी नहीं.
ना सेटा टैग हेतिला गत थरक किदु जानि हो आसी कि न
4941.
4941 of 2022.
फाइल अछि. सेटा रेस्टोर हो गेला. 4941. हां.
सेटा CRL
The file ta restore dismiss for default है ना बटन that has been restored. So you are the counsel then.
ना ना आउट नॉट.
So how can you withdraw it?
सर मोर जो सीआर तंगर पावर नै से विड्रॉ कर देले केस अबिका न्यूली मो को दी पड़े असला भी नाम रे.
अच्छा नुआ केस टा आसिला.
आज्ञा.
This is a technical how to get out of this.
मो गोटे सीआरएल में गोटे ये भी फाइल कर
present he has filed CRLMA 124 of 24 against the order of dismissal of 4941 of 22.
So if this is allowed,
earlier one.
So if this is allowed, that 494 that will be restored.
This has to be present one. 3863, but he doesn't have power in that case.
How can you withdraw it?
किंतु सीआरएल में से जो विड्रॉ कर देथिली सी तांको पाखे तो
I can dismiss it.
आज्ञा.
I can dismiss it for default.
आज्ञा.
So we'll call for that file tomorrow. List this matter tomorrow along with BLAPL number
3863.
3864. So that I can. That was dismissed by me, my order. All right.
Item 44.
Item 44. What compliance report कौन उड़ा सी?
The Lordship called for a report. Earlier bail was disposed of with a direction to dispose of the bail.
Regarding status of the trial.
Yes, my lord.
What is the status?
Near about 3 years he is in custody. Charge not yet framed as per my action.
The case record was adjourned from time to time on the prayer of the Learned Defense Counsel. So you don't appear there for consideration of charge.
Other accused person are there. They are taking time, my lord. I am in custody near about 3 years.
So you can be produced from custody for framing of charge. अपन टाइम नउछ
आमे नै अदर को जो माने बेल रे छ
मु सेरे बुझि गेले इथु पडगला पर मु बुझि गेलेनी पुरा
चार्ज फ्रेम
ये आवले माने सो नै जाउछंती टाइम
हमहु तो प्रोड्यूस करिवे जेलु ना जो दिन डेट
प्रोड्यूस करे कोन हो आपण यदि टाइम नेबे इफ द काउंसिल इज नॉट रेडी प्रोड्यूस से प्रोडक्शन नॉन चार्ज कैन बी फ्रेम्ड ऑन प्रोडक्शन
यस
What is this bail application?
Earlier, there is a direction to dispose of the case, my lord, within a period of
6 months.
6 months, my lord, on 5/10/2023.
5/10/23 एक केस रे
Bail appeal 12,550 of 22. Lordship may peruse that order.
That order is not there. That order is not there. You have all the case data and everything.
Yes, my lord. Case there is there. Net achi order.
Well, let us consider
I
it.
have seen, my lord.
Oh, solid.
On the ground that
Co-accused, two of the co-accused, your lordship granted bail. I have annexed the bail application order.
Let us see the FIR.
FIR.
Other going to Chota Vasa with his bicycle, another occasion, K. Murli Reddy, K. Bullu, K. Ravindra Reddy, attacked along with the deadly weapons due to previous enmity. Yes. Who are the witnesses? 161.
witnesses, my lord, the son of the deceased, my lord, K. Rajendra Reddy, who is the complainant. He has post-occurrence witness, and he has seen the petitioner soon after the occurrence that he is leaving the place, my lord. On that ground, your lordship has rejected. And
let us see that order. Kete BLPL?
BLPL
12550 of 22.
12550 of 2022.
Order dated 5/10/23.
By one co-accused, that is 28/6/2022, and Kirti Tripathi, who was the director of that foundation. I am the manager of the foundation.
Yes.
If there is not available, and so also the witnesses examined that deposition copy.
Deposition copies?
I will supply them. Photocopy with me, I will supply this.
Up to that case, there you obtained. Learned counsel for the petitioner shall produce the copies of the depositions of the witnesses examined so far. Does this matter?
8th August.
8th August.
Item 46.
May I please, Lordship? The petitioner is in custody since 2/1/2022, and there is a dispute between brother and sister. Sister is the informant, and the brother is the accused, my lord. And there is a dispute between brother and the sister because, my lord, the brother-in-law, who was a drunkard and who was claiming the property from the father's house, there was consistent dispute, and on that date, my lord, it is alleged that these petitioners, due to previous cause, went and stabbed the deceased as a result of his death. The case was registered under section 302 IPC, my lord, and he is in custody since 2/1/2022.
Let us see the FIR allegation.
And FIR allegation is, my lord, as I have narrated before lordship, on the date of occurrence, while the deceased, who is the brother-in-law of the accused, sisters being the sister's husband, one sister's husband, due to the enmity because of the father's property at Bhubaneswar, my lord, there was quarrel, there was dispute previously. On that day, he trespassed in the house and killed him. That is the allegation, my lord. Your lordship previously has granted me, taking into consideration the length of custody, has granted me bail for 2 months, my lord. And I have also filed an application before the Sessions Court and others court, my lord, for expeditious trial. Your lordship will find, although he is in custody from 2/1/2022, and the case is posted for trial before the 5th additional session judge, this court is not in session since long, my lord. Either the court is lying vacant, my lord, for which there is no trial at all, no charge has been framed. And so there, your lordship are granted.
You were granted interim bail.
Your lordship was also, yes, 2 months. Your lordship was also pleased to call for a report regarding the delay of trial, my lord, from the lower court. Your lordship kindly peruse the report, but there is no latches on our behalf, no contribution for the delay on our behalf, my lord. So your lordship kindly consider. 2 ବର୍ଷ ହେଲାଣି ଟ୍ରାଏଲ ଆରମ୍ଭ ହେଇକିନି ଗୋଟେ ସାକ୍ଷୀ ଚାର୍ଜ ବି ହେଇନି.
Report of the court below shows that trial has not commenced as yet. The petitioner has, in the meantime, petitioner has been in custody for nearly 3 years, 2 years.
2 years.
2 years.
2 years, 7 months. 2 years, 7 months.
His earlier application was No, he was earlier granted interim bail as per order passed by this court in BLAPL number 10594 of 2022.
On 12/1/24, there also your lordship has observed that since he is continuing custody, not
Considering the delay in conclusion of the trial. Stop. The Dharmendra Rai, learned senior counsel, appearing for the petitioner, would submit that in view of that the delay in the trial cannot be attributed to the petitioner, who has been languishing in custody for more than 2.5 years.
Yes, sir.
Learned State Counsel, he may therefore be released at least on interim bail for some time. Trial आरंभ
Your lordship so is
Direct allegation.
trial आरंभ हो ना direct allegation.
Allegation.
But
I
Yes,
must,
that sword has also
of
been
course,
seized on behalf.
of course, I cannot make a submission, legal submission manner. There matter has been settled between the brother and the sister. The matter has been settled up by the intervention of the father and mother. The matter has been settled. Bhai bhoni bhitar gondol is the settle helani. The only eyewitness is the sister. And your lordship know the fate of the case.
And taking note of the fact that despite the fact that the petitioner has been in custody for more than 2.5 years, the trial has not commenced as yet. And there is nothing on record to show that such delay has been caused by the petitioner. Stop. In such view of the matter, the bail application is disposed of, directing the court below to release the petitioner on interim bail for a period of 2 months. It shall be open to the petitioner to move the since the presiding officer, since no presiding officer is presently posted to the court, it shall be open to the petitioner to move for transfer of the case.
408, that is 408. 407, your lordship's power.
Yes.
High Court's power. 408 is Sessions Court's power.
To move? What is it? To any other court. Yes.
If such application is filed by the courts.
If such application is filed, the same shall be considered. Considered liberally.
47. Earlier bail application was not placed under annexure 2, page 20. Custody since 1 year above. Trial has not been started. 25 charge sheet witnesses are there. As per the charge sheet, 25 charge sheet witnesses. Till the trial has not.
No, when were you taken to custody?
16/6/2023. 17/6.
17/6/23.
What is the quantity?
120 kg.
2%.
Seized from their exclusive possession. Mediation.
On the road was seized, but
The petitioner is in custody since
17/6/2020.
17/6/2023. In connection with such and such, it is alleged that the petitioner and another person were in possession of contraband ganja weighing 125 kg?
120 kg.
128 kgs.
120 meter.
Sorry, 120 kgs when they were apprehended by police. It is submitted that despite being in custody for more than a year, trial has not commenced as yet. It is further submitted that the petitioner may at least be released on interim bail. Learned State Counsel has opposed the prayer for bail by submitting that the contraband was seized from his conscious possession. Having regard to the submissions as above and the fact that trial has not commenced. Despite the petitioner being in custody for more than a year, the bail application is disposed of, directing the court below to release the petitioner on interim bail for 2 months.
Same.
Same.
No accused.
Same.
Item 48.
My lord, this present petitioners, my lord, moved the
Bail out of pani, no?
earlier, my lord, fourth time this present petitioner before your lordship. And
Yes.
bail application was not pressed, and my lord, the order was also passed. And your lordship was pleased to allow interim bail for some period, and it has already been extended for some time. And in due time, my lord, this present petitioners, my lord, abiding the condition, my lord, appeared, and now he is in custody. And she never violated the terms and conditions which has been imposed by this.
No, no, no. No, I will not consider this.
My lord, here,
Whatever relief was required to be granted has been granted to you.
my lord, for a moment, my lord, that out of 38 charge sheet witnesses, 18 witnesses has already been examined till date, my lord. And
Bring the copies of the depositions, let us see.
yes, my lord. I am handing over just now, my lord, that these are the copy of the deposition. And I am charge sheet again. Charge sheet has already been submitted on.
Who are the main witnesses?
306, charge sheet submitted under section 306. And not 302 is not there, my lord, in the charge sheet. Charge sheet submitted that petitioner is in custody since 10/4/2022. And on the alleged date of occurrence, my lord, it is admitted case of the prosecution that he was not there in the home. Rather, he was in his shopkeeper, my lord, his shop, and then he accompanied with the deceased and others, my lord, to the hospital. And during course of the treatment, my lord, she died. My lord, my humble submission before your lordship, my lord, that I am in custody since 10/4/2000.
You have the case diary?
No, my lord. First time is just.
No, no. Who are the main witnesses?
Main witnesses ସେମିତି କେହି ନାହାନ୍ତି ତାଙ୍କ ଘର ଲୋକ ଅଛନ୍ତି କିଛି ଆମ ଘର ଲୋକ କିଛି ଆଜ୍ଞା ଅଛନ୍ତି ଆମ ଘର ଲୋକ ଆମକୁ ସପୋର୍ଟ କରୁଛନ୍ତି ତାଙ୍କ ଘର ଲୋକ ତାଙ୍କୁ ସପୋର୍ଟ କରୁଛନ୍ତି even if my lord accepting the prosecution allegation
already bring
One PW 15 elder brother of the
ଆଜ୍ଞା ତାଙ୍କ family
deceased.
member ସିଏ ଆଜ୍ଞା କିନ୍ତୁ ସିଏ କହୁଛନ୍ତି କହୁଛୁ କିନ୍ତୁ my lord that in since 2022 I am in custody my lord since 10/4/2022.
My lord,
And my lord,
in this matter, I am appearing for them.
Cause of death hochi my lord that charge sheet submitted under section 306. 302 has already been deleted. I have no intention, nothing, my lord, and I have sufficiently been punished, my lord. 2022, 23, 24.
No, no. You should, if you have been sufficiently punished, being an innocent man, you should file a case against the state for false implication.
For the sake of argument, my lord.
Not argument.
My lord,
I am in
22,
23, 24
No, no, no. Nobody.
ମୁଁ 306 ରେ ଚାର୍ଜ ସିଟ୍ ହେଇଯାଏ ଦେଖନ୍ତୁ ସ୍କୁଟିନ କରନ୍ତୁ ଆଜ୍ଞା ମୁଁ it is a copy of the deposition.
My lord, charge sheet filed under section 498, 304B, 34,
406,
406, 306.
306.
304B ଅଛି ପରା?
ଆଜ୍ଞା
My lord.
304 ଅଛି ଆଜ୍ଞା.
The PK Biswal appears for the informant by filing Wakalatnama. Learned State Council shall produce the case diary. Learned Counsel for the petitioner has produced copies of the depositions of some witnesses examined.
17 witnesses.
17 witnesses
17
who have
witnesses.
been examined so far during the trial. Same be kept on record. List this matter. Okay.
Next week.
Next week.
On 16th August. Yes.
My lord, I pray, my lord, my mother's health condition is very serious, my lord. If your lordship will release me some period, my lord, interim bail, 1 month, because I will never violate, my lord, because
No.
your lordship was released me interim bail and I surrender in time, my lord.
No, no, no.
306 ରେ ଚାର୍ଜ ସିଟ୍ ହେଇଛି for some
304B ଟାକୁ ଆପଣ କାଇଁ ignore କରୁଛନ୍ତି?
ନାଇଁ 302 ନାଇଁ my lord, for some period, my lord.
304B ରେ କାଇଁ ignore କରୁଛନ୍ତି ଆପଣ?
I am not a habitual offender, my lord.
Habitual offender କଣ? ମାନେ ତା କଣ ସେ ସବୁଦିନ ବାହା ହେଇକି ତା ସ୍ତ୍ରୀକି ଯେତେବେଳେ ସ୍ତ୍ରୀ ଆସିବ ତାକୁ ଚଢିକି ମାରିବ ତାକୁ habitual offender?
ଆଜ୍ଞା appear କରିବି
ନା।
ଏବଂ ମୁଁ ନିଜେ ବି ଆଜ୍ଞା
No,
ନେଇକି
no,
ଯାଇଥିଲି
you go on arguing for the entire day. I said no means no.
My lord, within
ହବ ନାହିଁ। ଆପଣ କାଇଁ
1
କରୁଛନ୍ତି?
year,
Why are you saying so?
sorry,
He has got every right to make his submission to try to convince the court. The court is not being convinced. Yes. Item 49.
Item 49.
Yes.
The earlier bail application was filed, your lordship, and there has been given direction to surrender first or second.
Yes. Same order? Yes.
That has not been complied, second application.
One thing you say pay the pay. In the meanwhile, the co-accused person religion bill. The parity only one word may kind be added. Your lordship.
No. So you file a fresh application.
This is fresh.
No, why C3 modification pakuna? C3 modification pakuna, I'll grant that. I'll say that you want parity. I'll grant parity. But provided you file an application for modification in that case. Say the set of modification file I'll call it next week. In the meantime, you file a petition for modification. And this you will not place.
This may be taken up along with your lordship other 3 bail application pending your lordship. Same case.
No, that's all right. That's all right. First, each of regularize karuntu.
For that I'll pay.
You understand, Mr. Jana, what I'm saying?
That's
You
correct.
file a petition.
Thinking so, your lordship.
Yes, list this matter next week.
Along with your lordship, other bail applications for this case is concerned. How much had there are 3-4 options.
ସମସ୍ତେ ରିଜେକ୍ଟ ହେଇଥିଲା ଗୋଟେ ଗୋଟେ ଫାଇଲ ମାନେ ଫାର୍ଷ୍ଟ ଅର ସେକେଣ୍ଡ
ଏଟା ସାଙ୍ଗରେ ଆସୁ ତା ସହିତ ଆଇ ଫାଇଲ କରିଦେବି ଆଗଟାରେ ଆଉ
Along with ABL number? There you number. Yes.
Supplying the number.
Yes. Item 50.
Next to your lordship.
Yes.
Item 50, may I please, your lordship. In the vacation, this matter was listed, your lordship. The petitioner is the mother-in-law of the victim girl, whose father is the informant in this case. Your lordship, I had obtained an interim protection on the ground that there has been a change of exceptional circumstance in this case, whereas the informant has been examined. I have obtained original copy of the deposition. Without going to the merits of the case, your lordship, I humbly pray that my lord may kindly accept the copies. And
have you complied with the previous order?
My lord.
You have complied?
Withdrawn, second one.
No, it was rejected, I think.
Yes.
First withdraw itla, second ta rejected.
Rejected. Liberty to appear before the court and move for regular.
Yes.
And now you seek, you are absconding and you seek anticipatory bail.
My lord, I'm appearing for the first time in this case. Previous cases I was not appearing.
No, it's not a question of counsel. It's a question of the litigant.
My lord.
Counsel, whoever may be the counsel. What is the conduct of this litigant? The direction was given, not a direction actually. Liberty was granted to you to move for bail in the court below. You didn't do that. Again, anticipatory bail. How is it maintainable? Tell me.
My lord, just one submission. Your lordship will see there is exceptional change in circumstance.
No, what
from the informant itself.
No, it is like the application. We say it's he's a fence sitter. You stay out of the proceeding. You approach this court. This court rejects it on the ground that you have been absconding for long.
I humbly pray that let me obtain.
Wait. As it appears, the petitioner has been absconding for a long time. This court is therefore not inclined to allow the prayer. And even now you are absconding. You have not entered into the court process. And only because the informant turned hostile, now you will claim bail. Haba nahi?
Informant and also the.
Haba nahi? Haba nahi?
I pray that whether they have.
Informant katha dekhenge bada to bail.
I pray that whether they have applied or not, let me seek instruction.
Learning counsel. See, Pratik Naik, learning counsel for the petitioner.
If they have applied, I will submit
wants
in the
some
court.
time to seek instructions as to whether the petitioner had appeared and had appeared in the court below, seeking bail.
Right.
So, let's just matter next week.
Interim order.
No.
I don't. Just checking.
Nothing.
First time I asked.
No.
My lord, first time only I'm asked. No adjournment I was seeking. I was not.
No.
Just till 1 week.
No chance. No. 1 hour pe habani.
My lord, one chance if the person has not followed the court's conduct in the previous bail, I will withdraw it.
No.
My lord, kind.
No.
My lord, kind.
Absolutely not.
My lord, just 1 week only.
No. I have not even.
I have not seeked adjournment.
No means no, Mr. Naik. No means no.
My lord, kindly.
No. This litigant's conduct does not entitle her.
I was not a part of it. That's why I'm asking. My lord, if they have not done it, just one chance. I humbly pray. My lord, I will withdraw it myself.
No.
Kindly.
Next time. No.
Kindly.
Yes.
One chance, my lord.
No.
Kind. Quickly list item number 30.
Yes.
Obliged.
Item कितने 30 में?
The plaintiff is the appellant.
Is a कौन?
Against the reversing.
Order of 12. Okay. Yes.
Where the suit was filed by the plaintiff.
Confirming or reversing?
Reversing. Reversing and
Plaintiff is the appellant.
Plaintiff is the.
So suit was decreed.
Suit was decreed on the basis that the lease was granted by the Tahsildar in respect of the suit property.
So for title correction of ROR.
Correction of the record of right on the basis that they have acquired the title on the basis of the previous lease by the Tahsildar. And the lease patta was also produced, that is Exhibit 4. Trial court relied upon that exhibit lease patta and said that they have acquired the title on the basis of that lease. And the government did not filed any rebuttal evidence disputing the lease patta. So therefore that was believed by the trial court. Where some of the villagers, suit was filed because some of the villagers disturbed his possession. So therefore he filed on the basis.
No, what is the property?
That property is a agricultural property, and out of 2 acres some odd 50 decimals of land was leased out in his favor as a landless person. And the patta was also issued. Thereafter, because
before vesting, was that lease granted before vesting?
After vesting.
On what basis was it granted?
Well, this was granted under the OGLS Act. He applied for the
OGLS Act from Bhubaneswar?
No.
Oh?
I am Bhadra, remote village. Bhadra.
OGLS Act as a landless laborer, grant of lease.
The lease was granted.
Mr.
Again, the appellate court has reversed the finding.
Let us see.
Well, that finding was reversed by the appellate court in a very misconceived, by recording a very misconceived finding that the suit is not maintainable in view of section 16 and 12 of the OPL Act. That is the sole finding recorded by the appellate court. Without going to the evidence, without going to the legality of the finding recorded by the trial court, I said that since it is a government property has been recorded in the name of the government, so therefore the suit is barred under section 12 and 16 of the OPL Act.
Where's the finding? Let us see.
Yes, quoted the provision, and the Lordship can see paragraph 16 of the appellate court.
Yeah, he says that place the settled upon his application, permanent agricultural lease.
So here in this case at hand, after getting permanent lease granted by the Tahsildar Bhadrak and subsequently suit stands recorded in the name of the government on Anganwadi Khata in MS Khata number so and so, plot number 1973. The plaintiff has challenged the same being agreed with the recording of the land in favor of the government. So originally the plaintiff has no right title interest over the suit land. His claim is only basing upon the lease granted by the Tahsildar Bhadrak. Therefore, keeping in view the aforesaid position of law and the section 12 and 16 mandate in OPL Act, the plaintiff could have made redress to the forum as per the statute provided under the OPL Act. OPL Act, not before the civil court, because in view of the aforesaid position of law, the civil court has no jurisdiction to decide the matter in controversy between the parties. This is in substance, this is the finding. And so far as the lease is concerned, because I have claimed my title on the basis of that lease patta, and thereafter on payment of rent to the government. Government accepted the rent for more than 12 years. So therefore, he acquired by operation of law, he acquired the status of settled right.
We'll admit it. On the only one point, only one question.
Only one point.
C.
Yes.
Yes.
And government did not prefer, the very peculiarity of this case is government did not prefer an appeal.
Third, Sri N.K. Sahu, General Counsel for the appellant, peruse the impugned judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial question of law. C. Page 11. Page 11 the C touch. That will suffice.
Yes.
Isn't it? Issue notice. I think state is there.
State is there.
You can accept notice.
But the suit was decreed as it appears.
Suit was decreed, it was reversed.
It was reversed.
But can you not accept notice?
OPLE proceeding was initiated and
No. There is no.
There is no OPLE proceeding. Lease was granted. Agricultural lease in 1972-73. That's what I find.
Yes.
And he claims to have been paying rent. I don't know. We'll have to go through the evidence. Now, the suit was decreed. The cause of action, he must have shown that he was disturbed by the villagers. That is why he claimed the title.
Yes.
The land stood recorded in the name of the government, Anganwadi.
But as he claims that.
So he has obviously
He's under exhibit 4. I have produced the lease. But
so ease was granted, then the government would not have thought it proper to go in further appeal.
So what has happened? Let us see. So you can accept notice.
If it has been.
Yes,
Only state is a party.
No, state and other.
Others are there. All right. Issue notice to opposite party numbers 1 to 5 by registered post with AD, returnable within 4 weeks. The requisites be filed within 3 working days.
Yes.
Leonard AGA accepts notice on behalf of opposite party number 6. On the respondent number 6, sorry, opposite party ko respondent kar do. An extra copy of the appeal memo be served upon him within 3 days. Call for the LCR. List this matter after service of notice. Yes.
If the state had not filed a first appeal,
no,
then the fate remains sealed.
Why?
The first appeal should have been filed.
Yes.
If there was any grievance seeking liberty.
But some villager may have filed that, I think.
Villagers.
So those villagers, the other private respondents.
Respondents.
They have filed. The question of locosity also arises. I don't know why nobody has raised or nobody has seen. They were parties, all right, because he made them parties. Let us see. Yes.
May I please your lordship? My lord, the conduct the appellate in a confirming judgment. Suit for pounding action.
Yes.
Was declared. And it was also confirmed by the first appeal.
Suit for permanent injunction. Simpliciter.
Simpliciter.
Yes.
And what happened, my lord? The case of the plaintiff is that the suit land is the self-acquired property of the plaintiff's vendor, whereas the defendant claims that it is the joint family property. This is the dispute. And the crux of the matter, my lord, prior to this, the vendor of the plaintiff had filed one partition suit. That was decreed, and it was challenged by the defendant, present defendants, before this Hon'Ble Court. And Hon'Ble Court directed, in view of Section 44 of the Consolidation Act, to the parties are directed to approach the Consolidation Authority for redressal. But instead of approaching the Consolidation Authority, when the title is disputed, not clear, the plaintiff's vendor has alienated the property to one stranger, and a stranger filed the suit. This is the case.
So this is sued by the stranger.
Suit by the stranger. Yes. Sued by the stranger.
Yes.
And take a finding this consultation factor was not looked into by the appellate court. It was not touched. Trial court has dealt it, but appellate court, first appellate court has not dealt it. My lord, you can see there is the issue number 3. Issue number 3, page 31 and internal page 7. Last
7. Yes.
On careful analysis of both the documents, documented as well as the oral evidence given by both the parties, it's found that. It has page 8, sir.
Yes.
Page 8, 32. Internal page 8 and
yes.
Page 32. Now coming to the next point, there the defendants claimed that the vendors of the plaintiff had filed a petition suit bearing title suit number 79/80
against the present defendants in the court of the civil justice in Jajpur, and the suit was decreed in favor of the vendor of the plaintiffs. But against that defendant had filed FA number 89/84, in which the Honorable Court set aside the order of civil justice in the division, directed the parties to file application under Consultation Act before appropriate authority to seek proper relief. He also filed the order of Honorable Court in FA number 89/84, which is marked as Exhibit A. We have our instance, it was filed. But that was not, your lordship can see, these consultation, these findings, that was not touched by the first appellate court. This is the vital argument, this is the vital point raised by the defendant, my lord. That is the ground number, my lord D, your lordship can see. Substantial question. Ground number D.
Ground number?
Ground B. Whether the honored court below are justified to pass a decree in favor of the plaintiff, even though the plaintiff's earlier suit was abated by the order dated 16/4/2088, passed by the honorable court.
Third Sri S.R. Patnaik, learned counsel for the appellant, peruse the informed judgments, considering the grounds raised and considering the submissions and the grounds raised. The second appeal is admitted on the following substantial question of law. D, page 9. Court kariye. Issue notice to the respondents by registered post with AD, returnable within 4 weeks. The requisites be filed within 3 working days. Call for the LCR. List this matter after service of notice.
Obliged.
Item 32.
Item 32 pass over tomorrow.
Pass over for the day.
Item 33.
Pass over tomorrow.
Pass over.
Item 34.
Pass over.
Item number 35.
Pass over.
Item number 36.
Yes.
The respondent, my lord.
It will be taken up tomorrow. He is asking for a passover. No, 36, Mr. Rao. Yes.
Next week, I can intercept next week.
What do you say, Mr. Rao?
Next week.
All right. Let this matter next week as paid for.
Item 38.
Lords, item 37, my lords.
Item
Last week also yeah hitla mention kar douchandi janu nanti my lords. Last week 38 ହେଇକି ଆସିଥିଲା ସେୟା କରିଥିଲେ.
ସକାଳେ mention କରିଥିଲେ next week.
All right. Let this matter next week. Next week is the next week is anyway. Make a mention on that day. You have to watch the mentioning then if you are interested in a matter. That is part of advocacy. No. That is part of advocacy. You have to watch, keep watch.
My responsibility, my lords.
Yes. 38.
Item 38.
Pass over.
Item 39.
39, yes.
39. The other side is state.
Yes. Yes. Let us see what is the substantial question of law. Whether the courts below decided the suit for permanent injunction, keeping in view the provisions of section 32.
Conforming judgment. It is basically a road has been carved out from my land.
Yes.
Even though the substantial.
Who filed the suit? You are the plaintiff.
I am the plaintiff appellant.
What was the suit for?
Suit for permanent injunction and for recovery of possession. The trial court, even though has gone deep into the merits of the case, but gave a finding negativing my stand. Only one issue, basing upon one issue, he has negatived the entire all the issues. Now the village road has been carved out.
Yes.
There was no requisition or acquisition of the amount from the state. 20 ବର୍ଷ ହେଇଗଲାଣି road ରାସ୍ତା ଅଛି. Now if my learned senior can
help that poor man in getting some amount, it will be well.
Provided it is found that he has title over that property.
Title is there established. I have got the documents. I have exhibited 1, 2, and 3.
But title was never claimed by you. Your suit was for permanent injunction, isn't it?
I have a title.
The suit was dismissed.
Yes,
On what ground?
I don't have any title.
That's all.
Hmm.
So that was challenged in the first appeal and confirmed.
Confirmed.
So very difficult to set it aside in second appeal. Concurrent findings of fact.
That is correct, Malad. Even though on a lighter issue, since even though if the decree is set aside and this appeal is allowed, assuming now the 20 years have passed by, road is there, villagers are using it. So some compensation if it is granted.
No, but that order cannot be passed in a
That I know
second appeal.
that
Had it been a writ application, I would have. But here,
that I know.
I can only test the correctness of the imputed judgment.
Let my senior.
But if you can convince the court that you had a title, but the courts below could not.
I can convince.
All right, then we'll hear it. We'll hear it.
I'll give a copy. Let it come next week.
Yes.
A week after.
Oh. Amar aro week re second appeal pathadi ketra ache? Dita ache. All right. Next week. That is all.
Item 35 was just passed. I was in another court.
Item 35 for admission.
Admission.
Okay. Yes.
Against a confirming judgment, the defendant number one's purchaser is in appeal. Originally the vendor of the present appellant was the defendant number one in the suit. There was an ex parte decree by the plaintiff. Then the defendant number one originally was living then. He preferred appeal to the lower appellate court. In the meantime, he also sold the property to the present appellant. So during the present pendency of the appeal before the lower appellate court, she expired. Thereafter, the present appellant filed an application on order to Rule 10, CPC, to be imputed as a party or substituted, and the appeal also continued with his presence. Now, even after that, also the appeal has been dismissed. Then the second appeal has been preferred by this purchaser. Now, the only question Lord here is whether the Sikkim tenancy, that too in respect of a homestead, will be heritable or not transferred.
That has been decided by this court.
This court decided.
Regarding that Sikkim tenancy being heritable and transferable and all that?
That is in respect of the agricultural land. Prior to that, even from the 1946 Tenancy Act was amended, Section 236, yes, my learned senior is correct. Amending that homestead properties are already, so now ignoring that 236 altogether, the lower appellate court has come to a conclusion that the judgment came subsequently, the full bench judgment came subsequently. This is not applicable to the present case. And
but the statutory provision was ignored.
Ignored, complete. 236 is not there in the judgment at all. I filed a written note of submission indicating very same fact. The written note of submission is there in the record also. I have taken only two grounds. That is one of the grounds, and one additional evidence was accepted without giving any opportunity. Of course, there is no. Where have
you given your substantial question of law?
Yes, yes, it is there. I am coming to the pages. Page 19, page 20, paragraph B.
Yes. That's DP Mahathir, Learned Counsel for the appellant. Appellants. Appellant. Peruse the impugned judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial question of law. Page 20, the B, capital B, juta, seta kar do. Tapos si juta am regular order ko seta kar do. Issue notice, itadi call for LCR and all.
IA what achi execution the step. IA number.
All right. IA so kar do. Further proceedings in execution case number 1 of 2011, pending in the Court of Learned. First additional civil judge, senior division Cuttack, shall remain state till the next date. Okay. Yes. Yes, Mr.
I may be excused to mention item number 44.
I claim that the matter will be taken 1 week after, because I don't have the exhibits.
Item 44. Item 44 টা করে দিও
1 week after.
তারপরে weekly review টা করো
And also I
week commencing 29th.
I am saying that Lordship may allow me to take the exhibits by pen.
Yes, yes.
Pen drive.
Yes. Learned counsel for the appellant is permitted to take soft copy of the LCR
LCR.
on a pen drive.
Sir, more wisdom to 47th.
47?
For respondent.
Item 47. Same.
I
We
beg
commencing 29.
I beg pardon, my lords, item number 43. The confirm judgment. The present appearance of the defendant's appearance in the Lord's courts below. Suit for eviction. No stay is there. Lordship may disposed of if any further cause of action arises.
Item 47.
43.
43.
I am for the appellant.
Decree has already been executed.
Honest.
Lordship may-
Since 2006, it has been executed.
So should I say that it has become infructuous?
As per the
ଆଉ cause of action ଦେଇ ହବନି infructuous ମାନେ infructuous ବୋଲି କହିବାକୁ ପଡିବ since it is submitted by Sri Manoj Verma, learned counsel appearing for the respondents, that sole respondent, that the decree in question has already been executed. Nothing further remains to be decided in this second appeal, which is therefore dismissed as infructuous. Yes.
49, my lord. I'm appealing for the appellant. I pray, my lord, 1 week after my
29th, week commencing 29th.
interim order to continue.
Interim order to continue. Yes.
Can it be on next week, my lord? I am for the respondent.
No. Yes.
Your Lordship, this is the written note of submission and memo of citation for the matters that were in part heard for RSA 180 of 2000. Your Lordship, it has been
Completely heard.
completed, reserved for judgment.
Yeah.
This item number 41. I've gone through the case, my lords. The only thing is I have to find some judgments, my lords. If your lordship may take it up next week, my lords, and I'll argue the matter.
It will come up next week. All next
My
week.
lords, grateful.
Item 41 next week. All right.